Indian tradition of Atithi Devo Bhava, we would like to welcome you all on behalf of the entire Mody family for gracing the occasion with your benign presence.
Firstly, we would like to extend a heartfelt welcome to our chief guest for this event, Ms. Jyotika Kalra, who is the first woman member of National Human Rights Commission. Our keynote speaker, Professor Dr. Bijay Singh Sijapati, Dean, School of Law, Tribhuvan University, Nepal. Words cannot express our gratitude and sheer delight at having you amongst us.
And a very warm welcome to Honorable President Mody University, Honorable Director Mody University, Honorable Registrar Mody University, Honorable Dean Administration Mody University, Honorable Dean of all schools, respected heads of all the departments, respected GMs of all the services, and all the other dignitaries present amongst us.
May Goddess Saraswati protect us. May all people live in peace with nature and other forms of life. May the daybreak of self-realization sweep away the darkness of ignorance. Let us fold our hands in front of the light that gives us prosperity, good health, and good fortune. Now, we would like to request Honorable Dean, School of Law, to escort all the dignitaries to come on the stage for the lighting of the lamp and begin the proceedings of this auspicious event with the blessings of Ma Sharda.
Thank you all. This has been such a blessing for all of us. Every step of the way, our institute has always supported and delivered the best. Keeping in mind the mission of our esteemed institution, which is to deliver world-class professional education and special focus on women education and India's cultural heritage. We would like to request our choir group to sing Kulgeet.
निर्माणों के पावन युग में हम चरित्र निर्माण न भूलें, स्वार्थ साधना की आंधी में वसुधा का कल्याण न भूलें। निर्माणों के पावन युग में मानागम अगाध सिंधु है, संघर्षों का पार नहीं है, किंतु वसुधा का कल्याण न भूलें, निर्माणों के पावन युग में। शील विनय आदर्श श्रेष्ठता, तार बिना झंकार नहीं है। शिक्षा क्या स्वर साध सकेगी, यदि नैतिक आधार नहीं है, यदि नैतिक आधार नहीं है। कीर्ति को मोदी की गरिमा में, संस्कृति का सम्मान न भूलें, वसुधा का कल्याण न भूलें, निर्माणों के पावन युग में। आविष्कारों की कृतियों में यदि मानव का प्यार नहीं है, सृजनहीन विज्ञान व्यर्थ है। प्राणी का उपकार नहीं है, प्राणी का उपकार नहीं है। मौलिकता के उत्थानों में जीवन का उत्थान न भूलें, वसुधा का कल्याण न भूलें, निर्माणों के पावन युग में। हम चरित्र निर्माण न भूलें, स्वार्थ साधना की आंधी में, वसुधा का कल्याण न भूलें, निर्माणों के पावन युग में। निर्माणों के पावन युग में, निर्माणों के पावन युग में।
Thank you. That was indeed a prosperous beginning to this event. I kindly request Honorable Dean and Head of Department School of Law to escort our chief guest, our keynote speaker, Honorable President and Honorable Director, Mody University, to come on the stage to be seated on the dais. Thank you, sir.
I would like to request Ms. Rubel to present a bouquet of flowers as a token of appreciation to the chief guest, Ms. Jyotika Kalra.
I would like to request Ms. Sakshi to present a bouquet of flowers as a token of gratitude to the keynote speaker, Professor Dr. Bijay Singh Sijapati. Please clap generously.
I would like to request Ms. Prakriti to present a bouquet of flowers as a token of appreciation to our Honorable President Mody University.
I would like to request Ms. Isha to present a bouquet of flowers as a token of our appreciation to our Honorable Director, Mody University. I would like to thank all the presenters for graciously greeting all our guests. Education. Education is the passport to the future, for tomorrow belongs to those who prepare for today. Education is the most powerful weapon we can use to change the world. the person who has consumed himself to change the society and light the darkness in lives of many students. I request Honorable Dean, School of Law, to please come on the podium and introduce the theme for our national seminar.
Honorable Ms. Jyotika Karla, first women member of the National Human Rights Commission, New Delhi. Professor Dr. Vijay Singh Bijapati, Dean, Faculty of Law, Tribhuvan University, Nepal. Respected Professor A.K. Dashura Sahab, our President. Professor Rajiv Ji Mathur, Director Must. Deans of all the respective schools, and Dr. Sukhveer Singh, Associate Professor and HOD, School of Design. Dignitaries and participants from outside, I mean out of this campus. All the GMs, AGM and other officer staff of the university, media persons, good morning to one and all. Theme is very simple. Though these words, all women rights are human rights, they were echoed long back in the year 1995 in the Beijing Conference, 4th International Conference on Women Rights. This was Article 14 of the Declaration of Beijing Conference. But still, inequalities, indignity prevails. Therefore, we are compelled again to look into the matter and decide whether we have been able to attain that height which we were thought of. That means whether the equality, right to equality, or liberty, or fraternity, or justice has been guaranteed to all the women of the world. It has rightly been said that best thermometer to gauge the progress of a society is its treatment to its women. If you really want to know about the progress of a civilization, or what kind of civilization we have got, what of the society we have got, whether all the fundamental rights have been guaranteed or not, then we have to look to the condition of women in that particular society. That is the best barometer of a civilized or non-civilized or uncivilized or half-baked society. Let me tell you very frankly, women empowerment is intertwined with respect to human rights. If you say empowerment of women, then we have to accept that human rights are part and parcel of women empowerment. If you want to empower the women, you are not empowering this society, not this generation, but the generations to come. Therefore, there is a famous book I am reminded of, Amartya Sen, Inequalities Re-Examined. Nobel laureate Amartya Sen has written a book, Inequality Re-Examined. We started with our journey with the Universal Declaration of Human Rights in 1948, and today is 2022. Whether we have been able to achieve the aims and objects which were written by the Universal Declaration of Human Rights, or CEDA of 1979, or the Beijing Conference of 1995. Therefore, persons are still compelled to think over and examine whether the inequalities which were prevailing at that time have been dispelled, or they have been narrowed down, or what is the position. I think since all efforts have been made, maybe legislative, maybe economic field, maybe education, but still much more has to be done. Therefore, with this subject, we have gathered here to examine and to gauge the progress we have made in this field. Thank you very much.
Thank you, sir. I hope we can all understand the need to talk about the rights of women. I request respected President Mody University, Professor P.K. Dashora, to come up on the podium and enlighten us with his valuable words.
ओम पूर्णमद पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते. नमस्कार. On dais, Madam Jyotika Kalra, Shriman Vijay Singh ji, Professor Rajiv Mathur, Professor Satish ji, Solanki Sahib, my dear faculty members, and enlightened students. Today's topic, all women rights are human rights, myth or reality. It is really very interesting one, but it is neither a myth nor a reality. It is something between these two. The reason being, the moment I see this topic, one question arose to my mind, that is a woman not a human being? And if a woman is a human being, then how can it be different from the human right? We are living in India, studying in must, and the Mody University of Science and Technology is known for many attributes, and one of them is we believe in our culture. We believe in preserving, protecting, and disseminating our culture throughout the world and humanity, where there has been very clearly mentioned that where women are worshipped, deities dwell there. Friends, this Mody University is one of its kind in our country. And this university is created to establish a thing that women are not different from the counterpart males. When we separately talk of women right, we also talk of child right. We also talk of parents' right. We also talk of old people's right. But why not we consider the whole gamut in totality and talk of human right? And once we ensure that human rights are taken care of, then there is no need of any other segment taken care of. I don't know, because I'm not a student of law, what are the special provisions there for women, and if there are certain special provisions, then why not they be for males also? What's the need of having some special provisions? And if there are certain special provisions in Constitution, then certainly all women rights are not human rights. because they have some special provisions. And if there is no special provision, then certainly the human right is a big set and women right is a subset of it. So we have to start thinking in some different way, that is, start thinking in a lateral way. We have always been trained to think in a classical way, a central way, a linear way. But the moment we start thinking out of the box, perhaps you will get many new ideas. And it is a national seminar being organized by Mody University. So I am sure that the outcome of this seminar shall bring beautiful results, important findings, and recommendations which can be implemented objectively so that we can bridge the gap between, if there is any, women right and human right. Thank you all, thank you very much. I wish all the success for this seminar. Thank you.
Thank you, sir. That was indeed a very informative thought. I request Dr. Rajiv Mathur, Honorable Director, Mody University, to come on the stage and address the audience.
Honorable Chairman, Shri R.P. Mody Sahab, respected Jyotika Kalra Ma'am, Professor P.K. Deshura Sir, Professor Vijay Singh Sirapati Sir, Professor Shastri Sir, Dr. Solanki, Deans, Head of the Departments, Principals, SEFS and Principal Mody School, guests, and dear students. First, I'd like to welcome all our guests on behalf of the management, faculty, and staff, and students. I'm extremely thankful to all of you who have taken time out from their tight schedules to come to this place. We are also thankful of Shastri sir, who roped them all and brought to this place and given this opportunity to all of us that we can hear them out. Every day, we think that we have traveled a long way when it comes to women's rights, women empowerment. We have a lot of success stories and this and that. So we think, yes, we have traveled a lot. But the very next morning, when we take the newspapers in hand, we understand there is a long way to go. हमारी सारे अचीवमेंट्स खत्म हो जाते हैं जब हम न्यूज़पेपर हेडलाइंस देखते हैं. And the final conclusion goes like this, that there is definitely a long way to go. Though I'm not from law, so I'll request ma'am and all the dignitaries who are here that in this national conference, we have to work on the things, we have to work on the steps that we can have a complete end to all those headlines in the newspapers. We have such a judiciary system that nobody can dare of indignified the woman. And we have to take some steps. Even in today's newspaper, I won't name the judges or the culprits, but some wonderful decisions have come, which will be milestones in the coming years. So I request all of you to give a thought to judiciary system, improvement in judiciary system, to put a complete stop on this thing. I wish all the best for this one-day event. Thank you so much.
Thank you so much, sir. That was indeed motivating and extremely informative. We are so honored and privileged to have you all amongst us.
We would like to introduce the chief guest for this seminar, Ms. Jyotika Kalra. Ms. Kalra completed her bachelor's in Commerce and Law from Delhi University and master's in Law from Kurukshetra University. Prior to her appointment as the first member of NHRC, National Human Rights Commission, she was a practicing advocate and advocate on record with the Supreme Court of India, having more than 27 years of experience. She was also on the panel of Supreme Court Legal Service Committee. Ms. Kalra has filed many PILs, notably the opening up a channel for females to practice as makeup artists in cine industry and non-recruitment of women in the armed forces. She was appointed amicus curiae in important matters, some of which concern the violation of rights of women. As a passionate activist, she has been associated with many NGOs. She has also been honored by the Supreme Court for her various books. The National Commission for Women awarded Ms. Kalra as an outstanding woman in the year 2014. I request the audience to please give a huge round of applause for such a skillful and proficient woman. I kindly request Ms. Jyotika Kalra to come on the podium and address the audience with her enlightening words.
Arjav. Thank you, Paridhi and Arjav. And on the dais, Professor Dashora, Professor Rajiv Mathur, Justice V.S. Dave, Professor Vijay Singh Sijapati. मैं भी प्रोफेसर दशोरा से बात कर रही थी कि आपने बहुत सारे सवाल खड़े किए हैं. अब अगर उन सवालों का जवाब नहीं दिया गया तो बच्चों को कन्फ्यूजन के साथ यहाँ से जाना पड़ेगा. बच्चों को मतलब मोस्ट ऑफ यू आर women, so I would like to address all those questions while I speak. और I am really thankful to the Mody University. Professor Shastri मुझसे coordinate कर रहे थे, and the moment I landed up in this auditorium, I told him that it was really very meticulously arranged. From the beginning till I landed up over here, every arrangement was wonderful. And I'm really happy to see the beautiful campus of the university. I feel like staying back over here and spending some time with you. And nice, everything is wonderful, very aesthetic and very nice. So thank you all that you gave me this opportunity. First, I would like to correct the record. My term with National Human Rights Commission as a member was completed on 4th of April, this April only. So recently my term has been completed. And as far as the first women is concerned, there were 2 women members prior to me. One was Justice Fatima Bibi and other was Justice Ranjana, Justice Sujata Manohar. So I am the first person from the civil society who is not a formal judge or a formal bureaucrat. So having corrected the record, now coming to the point. देखिए जो सवाल है मानवाधिकार का, और ये सब अभी छोटे हैं, मतलब all these kids, I ask कि कौन ऑडियंस में होंगे, तो मुझे थोड़ा छोटा छोटा बोलना पड़ेगा, मतलब ताकि सबको समझ में आए बात को. मानवाधिकार को अगर हम कहें तो उसको आप एक नेगेटिव राइट भी कहते हैं. अगर राइट फिलॉसफी में आप चलते हो, राइट को समझते हो, तो नेगेटिव राइट वो होता है कि वो अधिकार होना ही, मतलब अधिकार ही नहीं है, वो अधिकार नहीं है, मतलब वो नेगेटिव राइट है. जब वायलेशन होगी तो वो कहा जाएगा कि मेरा राइट वायलेट हुआ, नहीं तो जैसे. और मानवाधिकार जस्ट जब बच्चा माँ के पेट में आता है तो मानवाधिकार का कॉन्सेप्ट शुरू होता है. जैसे ही आप मानव बनते हो तो मानवाधिकार का कॉन्सेप्ट शुरू हो जाता है. बच्चा माँ के पेट में आया तो सिर्फ माँ की जिम्मेदारी नहीं है, वो गरीब हो सकती है माँ, उसके पास पैसा ना हो तो सरकार या स्टेट, जो वेलफेयर स्टेट है हमारे देश में, तो वो भी ये जिम्मेदारी ओढ़ती है कि जो प्रेग्नेंट महिला है अगर वो गरीब है तो उसको, आपने देखा होगा जो ANS नर्सेज हैं, ANM वर्कर्स हैं, वो घर जा जाकर उस प्रेग्नेंट महिला को कैल्शियम और इस तरह का भोजन देती हैं ताकि उसके गर्भ में पल रहा बच्चा ताकतवर हो। तो उसके साथ साथ उसको पैसा भी दी जाता है, खाने की चीज़ें भी दी जाती हैं। और जब बच्चे का जन्म होता है तो उस बच्चे का बर्थ रजिस्टर हो जाए तो वो भी उसका मानवाधिकार है, कि उसका जन्म रजिस्टर हो जाए तो वो भी उसका मानवाधिकार है। अब वो बच्चा माँ का दूध पीता है तो उसको माँ का दूध मिले, ये भी मानवाधिकार है। अब उसके लिए स्टेट फिर अगर माँ काम करती है, तो हमारा जब इंडस्ट्रियल डिस्प्यूट्स एक्ट बना 1940s 48 में समवेयर, तो उस समय पर भी ये लिखा गया कि जब कामकाजी महिला काम करेगी तो उसको फीडिंग इंटरवल मिलेंगे, मतलब बच्चे को दूध पिलाने के लिए उसको अवसर दिया जाए, तो बच्चे का वो भी मानवाधिकार है। शिक्षा, स्कूल जाएगा, फंडामेंटल राइट हो गया, राइट टू एजुकेशन 21A, तो अच्छी शिक्षा मिले वो भी उसका मानवाधिकार है। उसके बाद ऐसे गिनते जाओ तो मतलब हर चीज आपके मानवाधिकार से जुड़ी हुई। एक नेगेटिव राइट है, राइट नहीं है, होना ही, क्योंकि आप इंसान हैं तो आपके साथ ये सब कुछ होना ही चाहिए। अब हम उस मानवाधिकार को, मैं अगर प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट, कितने यहाँ पर लॉ के स्टूडेंट्स हैं, हाथ खड़ा करो जरा। अच्छा, तो समझते हो कानून, एक्ट कॉन्स्टिट्यूशन का फ्रेमवर्क है बड़ा, जो प्रोफेसर दशोरा ने बोला था कि ह्यूमन राइट इज अ बिगर थिंग। तो संविधान एक बड़ा स्ट्रक्चर है और उस संविधान के बेसिक स्ट्रक्चर से कानून बनते हैं, एक्ट्स बनते हैं। तो प्रोटेक्शन ऑफ ह्यूमन राइट्स एक्ट 1993 में बनता है और फिर वहां उस एक्ट में भी ह्यूमन राइट को डिफाइन कर दिया जाता है। और ह्यूमन राइट की डेफिनेशन एज पर द एक्ट ये है कि राइट टू लाइफ, इक्वालिटी, लिबर्टी एंड डिग्निटी एज enshrined in the Constitution of India, international covenants, but एक caveat लग गया, enforceable in the court of law। कोई भी अधिकार, मानवाधिकार इस श्रेणी में आना चाहिए, परंतु वो अदालत में enforceable होना चाहिए, उसको आप हासिल कर पाए। क्योंकि कोई भी राइट, अधिकार, तब तक उसका कोई मायना नहीं है अगर उसके लिए आपके पास रेमेडी नहीं है। समझ रहे हैं बात? सिर्फ अधिकार होने से कुछ भी नहीं होगा, रेमेडी होनी चाहिए। मतलब आप जब एग्जाम दे रहे हैं, आपको ये लगेगा कि चीटिंग नहीं होनी चाहिए, क्योंकि चीटिंग करके जो आप पढ़ लिख के आए हैं उसके भी उतने नंबर आएंगे, जो चीटिंग करके आएगा उसके भी उतने नंबर आएंगे। तो फिर कोई चीटिंग कर रहा है, आप कहते हैं सर ये चीटिंग कर रहा है, और सर का जी मैं क्या करूं, तो वो राइट ही नहीं है आपके पास। इसका मतलब कि आपका क्वेश्चन जो एग्जामिनेशन है वो फेयर होना चाहिए। ये अगर हम कहते हैं कि ये मानवाधिकार है और कोई चीटिंग करता है, उसके खिलाफ कोई कार्रवाई नहीं होती, उसका कोई रेमेडी नहीं है, तो वो राइट इनफ्रक्चुअस है, वो राइट का कोई मायने नहीं। तो इसलिए हर अधिकार मानवाधिकार की श्रेणी में तब आता है जब कोर्ट में वो राइट एनफोर्सेबल होता है। और आपके जो राइट्स की कैटेगरी कोर्ट में, मतलब अदालतों में जो एनफोर्सेबल होती है, अभी मैं कॉन्स्टिट्यूशनल कोर्ट्स को अलग छोड़ रही हूँ, सुप्रीम कोर्ट और हाई कोर्ट, कोर्ट्स में वो एनफोर्सेबल तब बनती है जब वो अधिकार आपके पास किसी कानून के तहत आते हैं, कानून से आते हैं। जैसे कॉन्ट्रैक्ट एक्ट है, सेल्स ऑफ गुड्स एक्ट है, पार्टनरशिप एक्ट है, या इंडियन पिनल कोड है। तो वहाँ पे जो जो कानून बनते हैं तो वहाँ पे राइट्स डिटरमिन होते हैं और रेमेडीज भी दी जाती है कि जो इनको वॉयलेट करेगा, वॉयलेटर के खिलाफ ये कार्रवाई हो सकती है। डैमेजेस का प्रावधान है, सेंटेंस का प्रावधान है। तो इस तरह से राइट्स को एनफोर्सेबिलिटी एक्ट के बनने से, लॉ के बनने से आती है। कोर्ट्स वो फोरम है जहाँ पे वो राइट्स या अधिकार एनफोर्सेबल किए जाते हैं। ये मोटा मोटी मैंने आपको बताया कि कानून क्या होता है और राइट्स क्या होते हैं। अब हम आते हैं अपने संविधान के ऊपर। जो मैंने आपको बताया, मानवाधिकार, लाइफ, लिबर्टी, इक्वालिटी और डिग्निटी, तो अगर हम अपने संविधान पे जाते हैं तो संविधान का सबसे महत्वपूर्ण जो चैप्टर है वो बताइए कौन सा है? कौन बताएगा? फंडामेंटल राइट्स। हिंदी में क्या बोलते हैं उसको? मौलिक अधिकार। तो मौलिक अधिकार बराबरी का कौन सा है बताओ? कौन सा आर्टिकल है? 14। तो मैंने जो इक्वालिटी आपको मानवाधिकार बताया वही आपके संविधान में राइट टू इक्वालिटी आर्टिकल 40 में। और फ्रीडम का कौन सा मौलिक अधिकार है? 19। फ्रीडम ऑफ स्पीच, फ्रीडम ऑफ टू कलेक्ट, स्पीच एंड एक्सप्रेशन। तो वो जो आर्टिकल 19 आपकी फ्रीडम की बात करता है, तो यहाँ मैंने आपको जो बताया तो लिबर्टी की बात बताई, जो एक्ट में लिखा हुआ है लिबर्टी। उसके बाद लाइफ का कौन सा मौलिक अधिकार है? राइट टू लाइफ एंड पर्सनल लिबर्टी, कि कुछ भी आपका जो कानून, अच्छा है आपके अध्यापक अच्छा पढ़ाते हैं, आपको फटाफट जवाब आ रहे हैं। तो फिर जो राइट टू लाइफ एंड पर्सनल लिबर्टी ये कहता है कि कोई भी किसी की जिंदगी या उसका जो लिबर्टी है उसको आप ड्यू कोर्स ऑफ लॉ के बगैर इन्फ्रिंज नहीं कर सकते। कौन सी इंपॉर्टेंट लीडिंग केस है राइट टू लाइफ एंड पर्सनल लिबर्टी का? मैंने कहा वेरी नाइस, दैट्स अ वंडरफुल आंसर, आई वाज नॉट एक्सपेक्टिंग दिस आंसर फ्रॉम यू। तो मनेका गांधी में ये आया, तो इट इज नॉट ओनली द रेमेडी थ्रू लॉ बट द रेमेडी थ्रू ड्यू कोर्स ऑफ लॉ। मनेका गांधी में सुप्रीम कोर्ट में जो बात निकल के आई कि सिर्फ कानून ही नहीं, वो सही कानून भी होना चाहिए जिससे कि आप किसी व्यक्ति की राइट टू लाइफ एंड पर्सनल लिबर्टी को इन्फ्रिंज करते हैं। और डिग्निटी की बात कहां से आई बताओ? संविधान में, और एक ऐसी बड़ी इंपॉर्टेंट लीडिंग केस में डिग्निटी की बात आती है। राइट टू लाइफ इंक्लूड्स राइट टू लिव विद डिग्निटी। ये आती है विशाखा वर्सेस स्टेट ऑफ राजस्थान की जजमेंट में, सेक्सुअल हैरासमेंट की। यही राजस्थान की ये वो एक ग्रुप ऑफ एनजीओ थी, विशाखा। विशाखा इज नॉट अ विमेन, इट्स ए ग्रुप ऑफ एनजीओज राइट फ्रॉम दिस स्टेट ओनली, राजस्थान। तो जब उसको सुप्रीम कोर्ट अपना जब डिसाइड करते हैं, तो सुप्रीम कोर्ट ने बोला कि जो राइट टू लाइफ है ना, इसी में दैट इंक्लूड्स इन इटसेल्फ राइट टू लिव विद डिग्निटी। सो वही जो मानवाधिकार जो निकलते हैं, हमारा यूनिवर्सल डिक्लेरेशन प्रोफेसर शास्त्री ने बताया 1948 में आता है, पर उसके साथ साथ ही हमारा संविधान बनने की प्रक्रिया भी वही उसी समय पे चल रही थी। 49 में हम अपना कॉन्स्टिट्यूशन को वो करते हैं, तो वही प्रोसेस चल रहा था। तो वहां पे जो मानवाधिकार की जहां बात है, उनको हमने सब अपने चैप्टर 3 फंडामेंटल राइट्स के सबसे इंपॉर्टेंट उसमें हमने वो सबको स्थान दिया। अब यहां पर इसी फंडामेंटल राइट से लिंक करते हुए मैं प्रोफेसर दशोरा का आंसर देना चाहूंगी कि अगर ह्यूमन राइट, विमेन राइट लार्जर है, स्मॉलर है, तो मैं इसको एड्रेस करते हुए बताऊंगी कि बताओ, अब अपने इतने सारे सवालों के जवाब दिए, तो कौन सा आर्टिकल है विच डील्स इन दिस चैप्टर ओनली विच डील्स विद द राइट pertaining to women, special provisions, article I'm really glad the quality of legal education you guys are getting. I'm really glad. So Article 15(3) of the Constitution deals with the provision that the state has the right to make special provisions for the relating to women and children. अब कोई मुझे ये भी बता दो कि ऐसी मजबूरी क्या आन पड़ी कि संविधान में तब 1948 में ये लिख दिया कि भैया स्टेट को महिला और बच्चों के लिए विशेष कानून बनाने का अधिकार हमने जाओ दिया। क्यों? Right. It's, you know, the right to equality, what does it mean, right to equality? आपको यहाँ पे एक प्रोफेसर की अपॉइंटमेंट करनी है, ठीक है? तो अब उन्होंने ये रिक्वायरमेंट है या कि भाई पीएचडी होना चाहिए लॉ में, ठीक है, इतनी उम्र होनी चाहिए। अब कोई व्यक्ति आके कहे कि मैं पीएचडी नहीं हो पाया, मेरी उम्र इतनी है, मैंने लॉ पढ़ा हुआ है, तो मुझे भी प्रोफेसर की अपॉइंटमेंट के लिए कंसिडर किया जाए, तो क्या हो सकता है ऐसा? तो राइट टू इक्वालिटी के इनहेरेंट एक राइट है, वो कहता है इक्वल्स टू बी ट्रीटेड इक्वली। इक्वालिटी मीन्स इक्वल्स टू बी ट्रीटेड इक्वली, मतलब सभी, अगर रिक्वायरमेंट पीएचडी की है तो सबका पीएचडी होना ही चाहिए, उसके बाद आपकी इक्वालिटी आएगी, इक्वल्स टू बी ट्रीटेड इक्वली। So from that concept of equals to be treated equally comes the concept of special provision for women and children. 1829 में कानून बनता है एबोल्यूशन ऑफ सती एक्ट। जो महिला का अगर पति की डेथ हो जाती है तो उस चिता पे वो जल के मर जाएगी, ऐसा कल्चर और कस्टम था। वो कुरीति थी। हमारे समाज से खुद उसके लिए आवाज उठती है ईश्वर चंद्र विद्यासागर, और कानून बनता है कि सती को एबॉलिश किया जाएगा। और इसी तरह 1900 उसमें कानून बनता है कि चाइल्ड मैरिज को रिस्ट्रेन किया जाएगा। उसी दौरान 1930 के आसपास कानून बनता है कि विडो री मैरिज, मतलब विडो शादी कर पाएगी। 1936 में पहली बार कानून बनता है विमेन्स राइट, लिमिटेड राइट टू प्रॉपर्टी एक्ट। उससे पहले महिला को संपत्ति में अधिकार नहीं था। और इसी 1930s में कानून बनता है जिसमें वुमेन को लीगल एजुकेशन लेने का अधिकार बनता है। तो कहने का मतलब यह है कि वो उसको बराबर की परिस्थितियां मिली ही नहीं। आप अगर आज कहो कि पुरुष के साथ वो बराबरी करेगी तो परिस्थितियां उसको नहीं मिली, वो ऑपरेशन, डिस्क्रिमिनेशन, शिक्षा को लेकर। तो इसलिए क्योंकि इक्वल्स टू बी ट्रीटेड इक्वली है, तो स्टेट को यह अधिकार दिया गया कि आप महिलाओं के लिए विशेष कानून बना पाएंगे। तो इसलिए आज भी अगर हम देखें तो शिक्षा में ऑलमोस्ट बराबर है, लड़के और लड़कियां हायर एजुकेशन में भी ऑलमोस्ट बराबर हैं। परंतु जो हायर लीडरशिप पोजीशंस हैं, डिसीजन मेकिंग प्रोसेसेस हैं, डिसीजन मेकिंग पोजीशंस हैं, वहां पे आज भी महिलाओं की संख्या 10, 11, 8, 9, 12 ऐसा परसेंटेज। आज की जो पार्लियामेंट है उसमें मैक्सिमम विमेन है, आज की जो पार्लियामेंट है, पर वो भी संख्या 13 पॉइंट समथिंग है। और इसी के चलते जो पंचायती राज लोकल बॉडी में रिजर्वेशन ऑफ विमेन 274 सम अमेंडमेंट ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया, जिसमें 33% रिजर्वेशन दिया गया और जो कई राज्यों में 50% दिए। तो ये जो रिजर्वेशन विमेन का आता है ये उसी आर्टिकल 15(3) से इमर्ज होकर आता है। और उसी के चलते जो रिप्रेजेंटेशन ऑफ पीपल एक्ट में अमेंडमेंट राज्यसभा में पास हुई थी मे बी 15 ईयर्स बिफोर, वो भी इसी से इमर्ज होकर आती है। तो महिलाओं को विशेष कानून देकर रिजर्वेशन, जिसमें एक तरीका है, क्योंकि आपको दिखता है कि महिला, जैसे राष्ट्रीय मानवाधिकार आयोग भी अब उसमें एक कंपलसरी विमेन मेंबर होनी चाहिए, मतलब एक कंपलसरी विमेन मेंबर होनी चाहिए, ऐसा 2019 में प्रोविजन आया। तो इस तरह की कुछ आपको फेवरेबल प्रोटेक्शंस महिलाओं को देनी पड़ेंगी अगर हम बराबरी की बात करते हैं। और बस अपनी बात को मैं समाप्त कर रही हूँ। एक, क्योंकि हम आज यहाँ सीकर में आए हैं, तो मेरे एक वकील थे, वो यहीं राजस्थान से बिलोंग करते थे। कह रहे मैडम क्या आप लड़का लड़की की बातें करते हो कि लड़कों को इम्पोर्टेंस मिलती है, हमेशा यही बातें करते रहते हो कि लड़कों को इम्पोर्टेंस मिलती है, लड़कियों को इम्पोर्टेंस नहीं मिलती। कह रहा जी सारा खेल जो है ना वो इकोनॉमिक्स का है। मैंने कहा भाई क्या खेल है इकोनॉमिक्स का? कहता जी ये कुछ नहीं है, ये सब चीजें पावर के आसपास खेलती हैं। कहता जी कल रात को 2 बजे मुझे घर पे पिताजी का फोन आया, तो इतने खुश थे कि बछिया पैदा हो गई। तो 2 बजे रात को उनसे सबर नहीं हुआ, 2 बजे उठा के फोन कर दिया कि बछिया पैदा हो गई। तो भैया जहां पे संसाधन होते हैं, अब यही गांव देहात से हम अपनी बात करते हैं, तो एक वही ऐसे मेरे वकील ही थे, उन्होंने बोला कि मेरे बुआ का एक बच्चा था, उसकी डेथ हो गई। 2-3 बार बात करी ऐसे, जवान था ये था। तो मैंने कहा उसकी मतलब बच्चा था या समथिंग। मैंने कहा उनके और कोई बच्चे नहीं है कुछ? नहीं मैडम 2 लड़कियां हैं, उनकी शादी हो गई है। मतलब उस लड़की को अपने बच्चा बोलेंगे तो सिर्फ मतलब लड़का बच्चा, मतलब सिर्फ मेल। लड़कियों की शादी होगी तो फैमिली का हिस्सा नहीं है। और वहीं उसी लड़के की बात है कि मैडम मेरी जो बुआ का जो दामाद है उसकी माँ विधायिका है राजस्थान से। मतलब अपने घर के पैदा की हुई लड़की को तो काउंट नहीं करेंगे, अपनी बुआ के दामाद की माँ अगर सीकर से विधायिका है तो वो मेरी है। तो भैया अगर आपको जिंदगी में कुछ करना है, महिलाओं के लिए मैं कह रही हूँ अवसर है, जिस तरह से लॉ की पढ़ाई करी है और बहुत अच्छी पढ़ाई करी है, तो इसको कंटिन्यू करना, उस मेहनत को कंटिन्यू करना, उस लगन को कंटिन्यू करना। परिवार आपकी पर्सनालिटी या आपकी प्रोफेशनल अचीवमेंट्स में बाधा नहीं आएगा, ये मान के चलो। ये पुरानी रिडंडेंट कहानियां आज भी इसको माना जाता है, पर उसको छोड़ो। थलसम्मा वर्सेस यूनियन ऑफ इंडिया की जजमेंट है सुप्रीम कोर्ट की, जिसमें वो आईएफएस थी, फॉरेन सर्विसेज। तब फॉरेन क्या बोल रहे, मुथम्मा, या मुथम्मा, यस, वेरी नाइस, वेरी नाइस। सो मुथम्मा, आई एम रियली ग्लैड। तो मुथम्मा की वो जो जजमेंट आती है, तो फॉरेन सर्विसेज में आई मीन लीडिंग केसेस इतने अच्छे से आपको पता है, इट्स रियली इट्स अप्रिशिएबल। सो उस जजमेंट में वो कहा जाता है कि जब फॉरेन सर्विसेज थी, उसमें कंडीशन थी कि अगर आप शादी करोगे तो आप अपने एम्प्लॉयर से परमिशन लोगे। और उन्होंने उसका बड़ा अच्छा लॉजिक दिया कि भैया क्योंकि लड़की अगर शादी करेगी तो उसके परिवार की जिम्मेदारियां बढ़ जाएंगी, जिसके बढ़ने से वो अपने काम को सही तरीके से नहीं कर पाएगी। तो फिर क्या बोले उस जजमेंट का, वो भी आप बता दीजिए। नहीं, कुछ और बोला था उन्होंने, जस्टिस नहीं, भगवती नहीं है, जस्टिस वेंकट चलैया। क्या बोले, उन्होंने बोला कि अगर शादी करने से महिला की जिम्मेदारियां बढ़ती हैं, तो उसी शादी करने से पुरुष की भी जिम्मेदारियां बढ़ती हैं। तो परिवार को आप ऐसा एक पार्टनरशिप, मतलब ये जेंडर स्टीरियोटाइप है, वो परिवार पति पत्नी अगर काम करेंगे तो पति पत्नी मिलकर परिवार को भी चलाएंगे, बच्चे भी पलेंगे बढ़ेंगे और बढ़िया पलेंगे बढ़ेंगे। तो जिंदगी में हमेशा इस मकसद के साथ रहना कि मेरी पहचान मुझसे बनेगी, और मुझे शायद अपनी पहचान के लिए सीरियस फोकस्ड, पढ़ाई नहीं, पढ़ाई तो सब कर लेते हैं, पहचान बनानी है, अपनी आइडेंटिटी बनानी है कि लोग कहे कि मेरी भुआ के दमाद की जो माँ है वो विधायिका है। ऐसी पहचान बनानी है कि दूर दूर से लोग, वो जो ऐसे कई एग्जाम्पल है कि आपके साथ अपने आप को कनेक्ट करें। थैंक यू वेरी मच।
That was indeed a visionary thought. Thank you so much, ma'am, for your valuable guidance. I am very glorified to take this opportunity to introduce our keynote speaker for this event, Professor Dr. Bijay Singh Sijapati, who is Dean School of Law in Tribhuvan University, Nepal. He is also a senior advocate of the Supreme Court, Kathmandu, Nepal, and member of IUCN, Commission on Environmental Law. He has done his PhD and Masters from University of Delhi. He has been a legal expert in the Ministry of Forest and Soil Conservation, and also senior legal specialist in Asian Development Bank or Debt Recovery Tribunal in Kathmandu. Sir has also been principal and lecturer of School of Business Administration in Crown House, London. He is an author of 7 books which throws a limelight on issues concerning environmental law and justice, which has also been given special reference in United Kingdom and United States of America. He was awarded Mahendra Vidya Bhushan in 2004 and Dirgha Seva Padak in 2012. I request audience to give a huge round of applause for such an inspiring personage. I humbly request you to come up on the podium and enlighten us with your words.
ये जो है इसको वो कर देना। ठीक है सर, ये कौन सा है? Respected chairperson Professor Dashora, chief patron of national seminar, Professor Satish Sastry, Dean, Professor Rajiv Mathur, Director and Patron of National Seminar, Chief Guest Jyotika Kala, First Woman Member, National Human Rights Commission, और मैं सोच रहा हूं कि मैं भी थोड़ा हिंदी में बोल लूं। ज्योतिका जी ने जिस तरीके से हिंदी में प्रवचन दिया, मुझे लगता है कि मुझे भी थोड़ा अंग्रेजी से बेहतर होगा कि हिंदी में कुछ शब्द आपके समक्ष पेश करूं। सबसे पहले मोदी यूनिवर्सिटी सभी को, सारे प्रोफेसर को, कर्मचारी वर्ग, विद्यार्थी वर्ग सभी को एज ए डीन फैकल्टी ऑफ लॉ तिरुवन यूनिवर्सिटी और एज ए डीन मेरे तरफ से सादर प्रणाम और हृदय से धन्यवाद देना चाहता हूं। सवाल मानव अधिकार या महिला अधिकार का जहाँ तक है, ये मेरा अपना एरिया नहीं है। मैंने तो 2002 में यूनिवर्सिटी दिल्ली से मैंने इन्वायरमेंटल लॉ में पीएचडी किया और मैं उसी एरिया में प्रोफेसर रहा। लिहाजा मुझे इतना तो अनुभव नहीं है जितना शायद ज्योतिका जी या प्रोफेसर शास्त्री औरों को है। लेकिन मेरा जहाँ तक मानना है कि ये अधिकार की बात है, हम अपना फर्ज अगर पूरा करेंगे, दूसरे का अधिकार आपसे आप रहेगा। एक फैमिली में चूंकि नेपाल भी हिंदू फैमिली बिलोंग करता है, कल्चर वही है। हमारे फैमिली में हम एक सास अपनी बहू से क्या ट्रीट करती है, ये बड़ी बात है। वहाँ से शुरू होता है हमारा ह्यूमन राइट। एक महिला माँ होती है, बेटी है, वाइफ है। जैसे कि अभी ज्योतिका जी ने कहा कि बेटा होगा तो ऐसा थोड़ा फ़र्क है। हम अभी डिफर ये करना चाहते हैं आप लोग के सामने कि मैंने सुना है भी और थोड़ा कुछ वक्त दिल्ली में रहते हुए भी अनुभव किया कि लड़के का डिमांड बहुत होता है शादी में। बेटी वाले बड़े ऑफर करते रहते हैं। ये बात नेपाल में नहीं है। जितना भी पढ़ा लिखा अच्छा पोजीशन में होगा, पहल लड़के वालों को ही करना पड़ेगा लड़की मांगने के लिए। ये फ़र्क है। आप जितने भी काबिल होइए, लेकिन लड़की वाले के वहाँ जो है क्या कहते हैं उसको, एक शादी के लिए पहल आपको करना पड़ेगा। ये ज़्यादा फ़र्क है। और दहेज सिस्टम नहीं है। दहेज सिस्टम नहीं है, इट मीन्स जो नेपाली मूल के, पहाड़ी मूल के हैं उनमें नहीं है। ये आपका बॉर्डर एरिया में भी हैं नेपाली सिटीजन जो आपके इधर से भी वो लोग रह रहे हैं, उनका तो रिलेशन है, लेकिन जो पहाड़ी मूल के लोग हैं वहाँ पे नहीं है। यानी आप बिना दहेज, बिना कोई शर्त आप लड़की मांगेंगे, शादी करेंगे। तो ये इससे भी क्या दिख रहा है कि नेपाल में शायद वुमन राइट्स ह्यूमन राइट्स है कुछ हद तक इस हिसाब से। मैं अब आ रहा हूँ कि आखिर है क्या नेपाल में। जैसे कि प्रोफेसर शास्त्री या ज्योति मैडम ने अभी कहा यहाँ के बारे में, सो व्हाट इज द प्रोविजन इन कॉन्स्टिट्यूशन एंड लीगल प्रोविजंस इन इंडिया। मैं आप लोगों को दिखाना चाहता हूँ कि नेपाल में है क्या। नेपाल का कॉन्स्टिट्यूशन, वहाँ का लीगल प्रोविजन या लीगल लेजिस्लेशन वगैरह क्या है, और सुप्रीम कोर्ट ऑफ नेपाल ने कितने केसेस में कैसे कैसे डिसीजन किया है, उसका थोड़ा सा ग्लिम्स मैं यहाँ देना चाहता हूँ आप लोगों को। अब मैं यहाँ आप लोगों को ये नहीं दिखाना चाहता हूँ, जैसे कि मैंने पहले यहाँ है अंडरस्टैंडिंग ऑफ वुमन ह्यूमन राइट्स। ये आप लोगों को सभी को पता है कि एलिमिनेटिंग all forms of discrimination against women. So, first of all, in regard of women human rights, here some glimpse regarding women human rights, that is women and men, and eliminating all forms of discrimination against women, number one. That is the fundamental objective of the United Nations organization, and mainly distinction, inclusions and restrictions. And lastly, violation of women human rights. Ensuring the women human rights by international human rights laws. ये आप सभी लोगों को पता है, यूनाइटेड नेशन चार्टर 1945। तो मैं इसके लिए भी ज़्यादा आप लोग का टाइम नहीं लूँगा। इसके बाद है यूनिवर्सल डिक्लेरेशन ऑफ ह्यूमन राइट्स 1948, जहाँ प्रिंसिपल ऑफ इक्वालिटी की बात है, प्रिंसिपल ऑफ नॉन डिस्क्रिमिनेशन की बात है, प्रिंसिपल ऑफ यूनिवर्सलिटी की बात है। इसके बाद है कन्वेंशन ऑन द पॉलिटिकल राइट्स ऑफ वुमन 1953। In 1965, Convention on the Elimination of All Forms of Racial Discrimination. यहाँ जेंडर फैक्टर और इश्यूज है। इसके बाद 1966 में इंटरनेशनल कवेनेंट ऑन सिविल एंड पॉलिटिकल राइट्स, जैसे कि ज्योति मैडम ने कहा था कि स्टेट की ड्यूटी ऑफ स्टेट्स कानून बनाना और लीगल रेमेडी देना, दीज आर द। इसके बाद है इंटरनेशनल कवेनेंट ऑन इकोनॉमिक, सोशल एंड कल्चरल राइट्स 1966 अगेन। (1967) Declaration on the Elimination of Discrimination Against Women 1967. Here is Nepal has already declared null and void of those legislation directly discriminatory towards women. International judiciary response on women human rights. So many cases, especially AS, that is Roma, Hungarian Roma, the case. शायद आप लोग सभी को पता होगा कि एक 27 साल की महिला जो हंगेरियन नेशनलिटी की, उन्होंने ऑपरेशन वक्त उनका जो है जो बच्चा पैदा करने का जो है भी ऑपरेशन किया गया बिना कंसेंट। बाद में इंटरनेशनल कोर्ट ऑफ जस्टिस पे केस फाइल हुआ और गवर्नमेंट को जो है कंपनसेशन देना पड़ा। ये बड़ा फेमस केस है। शेरा कमेटी ने इसमें डिसीजन किया है। शी claimed that forced sterilization is a violation of numerous human rights, including the right to dignity. The sterilization was forced because she was not given information about the procedure in an ethical own way and therefore was unable to make an informed choice. AS claimed that this was a breach of her right to appropriate health services, which caused both physical and emotional injuries. Also, that informed consent is based on a person's ability to make an informed choice, and its ability does not depend on the form in which it is given. नेपाल के बारे में मैं थोड़ा women rights in Nepal. Constitution of Nepal has guaranteed the rights of women as a fundamental right. जैसे अभी इंडियन कॉन्स्टिट्यूशन की बात हुई, नेपाल में भी फंडामेंटल राइट के तहत वुमन राइट्स का ह्यूमन राइट जो है, और वुमन कंप्राइज 51.5% पॉपुलेशन The judiciary is very positive in terms of recognizing the rights of women and also active in terms of issuing a different order in name of government. तो इस सवाल में कई पॉलिसीज, सो मैनी पॉलिसीज, सेवरल पॉलिसीज प्रोग्राम जो है नेपाल में अभी चल रहा है, और फिर भी नेपाल पुलिस जो है रजिस्टर किया है कि 15,719 कंप्लेंट्स रिगार्डिंग वायलेंस अगेंस्ट वुमेन एंड चिल्ड्रेन. आउट ऑफ द केसेस डोमेस्टिक वायलेंस 11,738, रेप 2,144, अटेम्प्टेड रेप 687, एबॉर्शन 29, सेट्रा एटसेट्रा. तो हैपन जो है judicialization of women human rights in Nepal, violence against women, equal right to property, right to reproductive health, right to identity of women, family and marital relation of women, equal right in employment, and special protection of women. कई केस हैं इम्पोर्टेंट जिसमें सुप्रीम कोर्ट ऑफ वर्डिक्ट वायलेंस अगेंस्ट वुमन, जेंडर बेस्ड वायलेंस नेपाल इज अ केस सपना मल प्रधान वर्सेज हिज मैजेस्टी गवर्नमेंट. That is declared that the legal provision related to rape chapter of Mulkian was discriminatory among women and unequal and resulted in the elimination of the provision in which rape offenders committing the same rape offense were given different punishment based on the character and profession of the victim. The important Lekpa Sherpa versus Government of Nepal, woman can rape another woman also. the decision made by the Supreme Court of Nepal, not only men, the woman also. Woman can rape another woman. In this case, a principle was pronounced that a woman can rape another woman, and that the offense of rape can also occur when a perpetrator uses artificial object to rape. Nepalese legal position in terms of rape is much broader and comprehensive, which has included the usage of any hard object, including penetrated by men. Likewise, Gha Kumari versus Sagar Bhatt, where the crime scene cannot be ascertained. Likewise, Bhupendra Khadka versus Nepal Army, consent obtained by an army officer who uses his position. यानी एक बड़ा पद में बहाल जूनियर से अनड्यू में भी डिसीजन मेक हुआ है. Likewise, Jyoti Paudel versus Government of Nepal, throwing acid was not yet incorporated. Fast track court. So, pertains to the cruel and inhumane offense of throwing acid. It found that since throwing acid was not yet incorporated in the Domestic Violence Act 2066, judgment needed to be delivered to make a provision for his offense in the same act as per the amount of offense. The decision was also made on the establishment of a fast track court. Likewise, Sharmila Parajuli versus His Majesty Government, sexual harassment at workplace. Supreme Court verdict, equal right to property. अभी नेपाल में यहाँ क्या है पता नहीं मुझे कि अगर लड़की शादी हो जाती है तो भी अपने पेरेंट्स से वो लड़के के बराबर उसका जो है अंश उसको मिलना है. यानी एक लड़का है एक लड़की है तो बराबर प्रॉपर्टी में बराबर हक लगेगा. शादी हो जाने के बाद भी हस्बैंड में भी है राइट उसका और अपने फादर मदर में भी है वो राइट. उसको प्रॉपर्टी आधा देने का जो है ये लेजिस्लेशन भी आ गया है और कोर्ट का डिसीजन सुप्रीम कोर्ट का है. अब यहाँ क्या है मुझे नहीं पता है. या likewise, Meera Dhungana versus Council of Ministers. Inheritance must be returned after someone gets married. ये right to reproductive health. So many cases. Anupama Rana versus Gorakh Shamsher Jabra. Prakash Mani Sharma versus Women Government of Nepal. That is here to maternity protection after determining the period of minimum maternity leave. ये तो शायद यहाँ भी है कि प्रसूति के वक्त जो है महिलाओं को जो है लीव देने का जो है उसका पाने का अधिकार. That is Safe Motherhood and Reproductive Health Rights Act 2075 BS. BS means विक्रम संवत हम लोगों का चलता है, ईस्वी संवत नहीं. सपोज फॉर एग्जांपल अभी 2079 चल रहा है हम लोगों का, आपका 2022. हाँ. So many cases decided by Supreme Court of Nepal regarding reproductive health rights of women during all steps of the criminal process also. Manju Tamang versus Government of Nepal, contraceptive methods and services. Likewise, Supreme Court also decide about the right to identity of women, identity-based citizenship under the case of Sunil Babu Pant versus Council of Ministers, and also recognized by the Supreme Court of Nepal that third gender as opposed to just male or female, third gender, that is, it is ordered that people from the third gender community should be given passport specifying third gender as opposed to just male or female. Family and marital relation. Sapnamal Pradhan versus Council of Ministers. Marital age of men and women. So this time, Civil Code 2017, the age of this purpose is 20, both girls and boys. Equal rights in employment. That is Reena Bajracharya versus Government of Nepal, Sita Achar, Ministry of Health, Prakash Mani. So, protecting the rights of women working in dance and cabin restaurants also, and unequal probation periods for female employees, and provision of services and facilities were decided in the case. These are the cases. Likewise, special protection of women as a woman human rights, that is for those Kshetri Council of Ministers, Raju Prasad Chapagai versus Council of Ministers, that is reservation to Tirubhavan University employees without making a law is against the Constitution, and in this case, actually to protect the women's right to reservation, women's rights, as well as under the Raju Prasad Chapagai regulates gender-friendly advertisements and age limit for receiving. So, lastly, I think the government of Nepal has already made major laws reflecting the order of Supreme Court in the process of execution. The government has also made broader plans, policies for implementing the broader aspiration of the court. The private-public partnership is encouraging to materialize the rights of women in Nepalese context. All major international treaties are ratified by the government of Nepal and is already reflected in the municipal laws of Nepal. Lastly, the women rights are human rights, reality, not myth. Right to life, freedom, equality, and dignity are important areas of human rights. Equal treat of human being is basis of human rights. Eliminating, reducing the discrimination, inclusions, restrictions are motto of human rights. Equal participation, access, and recognition of all human beings are object of human rights. So, in this way, hence the maximum whether women human rights are human rights or myth or reality in Nepalese context, the research shows that it is reality than myth in the Nepalese context. The Supreme Court, along with the government of Nepal, is enforcing with good intention of human rights in different subject case areas. Thanks.
Firstly, I would request the audience to please give a huge round of applause for such an inspiring personage. Thank you, sir. That was indeed enlightening. Now it is time for a very important announcement. We are going to release our annual legal journal, so please put your hands together. This journal will contain information relating to contemporary issues as well as all the research done by various authors over key sensitive issues concerning contemporary law and justice in our society.
I now request Honorable Dean Sir, School of Law, along with all the dignitaries on the stage to inaugurate our annual legal journal.
Your benignant presence for the same has made this release of paramount importance. I request the audience to please clap generously for the same. Thank you to all our dignitaries. Former Rajasthan High Court Judge Vinod Shankar Dave was elected President of Association of Retired Judges of Supreme Court and High Court's National Executive at its 9th conference in July 2011. Justice Dave had headed the State Law Commission in 1993 and later the State Consumer Dispute Redressal Commission. He is currently working as the chairman of the board of Jaipur-based Center for Community Economics and Development Consultant Society.
Due to some difficulties, Honorable Justice V.S. Dave was not able to join us for the seminar. However, on his behalf, he has sent Sir Rishi Agarwal from Rajasthan High Court to deliver his message.
Therefore, I request Sir Rishi Agarwal to please come up on the stage and deliver his message.
Respected dignitaries sitting on this dais, speakers for today's session, Madam Jyotika Kalra, Professor Dr. Vijay Singh, guests from other institutions, faculty members and students. A very good morning to you. As just told that I am here to address Honorable Justice V.S. Dave's message to you. A part of that, I am also attending the seminar here as a volunteer from Rajasthan Education Trust. So the message which Honorable Justice V.S. Dave sir has sent, I just read it out if the dais allows me to do so. Good morning and greeting to all present in this auditorium. I deeply regret for reasons of health I could not make my journey possible and is deprived of learning from the learned discourse likely to be made in this seminar on one of the most important subjects being discussed from times immemorial. I was reading autobiography of former First Lady of USA, Miss Hillary Clinton, Living History. When Hillary visited India, she had agreed to make a major speech on women's rights at the Rajiv Gandhi Foundation, but she was having trouble writing it. She was looking for one clear image that would express what she wanted to say. At the women's luncheon, Meenakshi Gopinathan, the principal of Lady Shri Ram College, a secondary school, presented her a handwritten poem by an 11-year-old schoolgirl, Anusuya Sen Gupta, inspiring the former to understand the concept of human rights, rather say social justice, to half of the population of the world, namely the women. Hillary said she had no subject in mind to address the forthcoming Women Conference in Beijing. The note by Anusuya read as under: too many women in too many countries speaking the same language of silence. I trust and hope Madam Jyotika Kalra and Professor Dr. Bijay Singh Sijapati would throw light on subject and provide an opportunity to the students of this prestigious exclusive women university. I, on my behalf and trustees of Rajasthan Education Trust are grateful to the organizers, especially the directors, patron sirs, Shastri sir, for providing this platform to acquaint the students about the aims and objects of Rajasthan Education Trust, which is to have excellence in education all around. Justice V.S. Dave. A part of this, जैसा मुझे आदेश किया गया है, हमने एक यहाँ पे राजस्थान एजुकेशन ट्रस्ट की तरफ से कॉन्स्टिट्यूशन का एक एग्जीबिशन लगाया है बाहर, आप लोगों ने सबने एंट्री करते हुए देखा होगा. सो द आइडिया बिहाइंड दैट एग्जीबिशन इज़ कि हम लोग सब कॉन्स्टिट्यूशन की बात करते हैं, बट वो कॉन्स्टिट्यूशन बनते वक्त उसकी आत्मा क्या थी, वो सारा उस पर आप मोहनजोदड़ो की सील देखेंगे, उस पर आप गुरुकुल, वैदिक गुरुकुल देखेंगे, उसमें आप बहुत सारे चित्र देखेंगे जहाँ से वो 22 पार्ट आए. तो मेरी आप सबसे रिक्वेस्ट है कि आप अगर अभी आते वक्त उस एग्जीबिशन को नहीं देखे हैं तो प्लीज़ एक बार उसको ज़रूर अवलोकन कर लें यहाँ पे. इसी एग्जीबिशन को हमने एक बुक फॉर्म में भी राजस्थान एजुकेशन ट्रस्ट की तरफ से इंस्टीट्यूशंस के लिए एक not for academic purpose, for the libraries of institution, we have printed this and we are gifting this for free of cost, not for academic purpose. So I would take this opportunity to give this book from Rajasthan Education Trust behalf to Mody University. Thank you. Along with this, I am also submitting this as small report of activities. Thank you very much. I would request Ma'am Jyotika Kalra ji and all the present people here to help us the trust in taking this issue further. Thank you very, very much. I will not take any more time. Thank you, everyone.
We thank you and your efforts are duly noted.
Gratitude should be an attitude. Therefore, without further ado, I would request Honorable President Mody University to present Ms. Jyotika Kalra, our chief guest for this event, with a shawl and a memento as a token of our gratitude and appreciation. I request the audience to please give a loud... Thank you, sir.
I kindly request respected Director Mody University to present Professor Dr. Bijay Singh Sijapati, our keynote speaker for this event, with a shawl and a memento as a token of our gratitude and appreciation.
I request the audience to please clap generously for the same. Thank you, sir. I humbly request Honorable Dean, School of Law, Mody University, to present Professor P.K. Dashora, our Honorable President, with a token of our gratitude.
Thank you, sir. I cordially request Honorable Head of Department, School of Law, Mody University, to present Dr. Rajiv Mathur, our Honorable Director, with a token of our gratitude. Thank you, sir.
Now it's time for a monumental occurrence. Achievers in life are accomplished both in skills and experience. They are people who create futuristic pathways for others to walk. They carry their visionary thought and make a difference in the lives of people. And on this note, Mody University is presenting the Women's Achievers Award. So please give a huge round of applause. To present this award, I request Honorable President and Honorable Director, Mody University, to felicitate our chief guest, Ms. Jyotika Kalra, first women member of NHRC, the prestigious Women's Achievers Award in our seminar for her monumental accomplishments. We all aspire to be successful like you, ma'am. We are now going to begin with our first technical session, which will resume in 2 minutes. Yes. Now I kindly request Dean Sir and Head of Department to escort all our dignitaries from the dais to their respected seats.
Arjav, मतलब क्या होता है इसका मतलब? It looks sounds like more like an English name.
It's 108th name. just switch, finish it, and switch. Yes. Now I kindly request the audience to please be seated in their respective seats. All the volunteers who are told to please tell them to be seated. Now, we will move on to the first session of this national seminar. The chairperson for this session is Professor Dr. Madhu Shastri, former Dean, Mody University. The co-chairpersons are Dr. Sushma Gaur, a principal at St. Wilfrid's College of Law, Jaipur, and Dr. Bharat is an assistant professor in Chandigarh University. So without further ado, I would like to request the panelists for this session to come up on the stage and take their seats on the dais.
Can we have a huge round of applause for our learned panel? It is my great honor to introduce our excellencies to the audience. Introducing our chairperson, Professor Dr. Madhu Shastri. Dr. Madhu Shastri has been a professor in University of Rajasthan. She is the first woman in the state of Rajasthan to have her PhD in law. She also has been the Dean of Faculty of Law in Mody University, Jaipur. She has written books on varied issues and more than 4 dozen articles for national as well as international journals. Her book on the issue, The Status of Hindu Women, has been appreciated by the Indian Parliament. Thank you, ma'am, for gracing us with your esteemed presence.
Now, I would like to introduce our co-chairperson, Dr. Sushma Gaur. Dr. Sushma Gaur is the principal at St. Wilfrid's College of Law, Jaipur, with an experience of 18 years. She is always willing to mentor students. She has graduated and done her post-graduation from University of Rajasthan and obtained her PhD on rights of tribal people and has published various research papers. We are very grateful to you, ma'am, for marking your presence here.
Now, introducing our next co-chairperson to you, Dr. Bharat. Dr. Bharat is an assistant professor in Chandigarh University with 14 years experience in law and 16 years of research experience. He is a professional expert in Ministry of Technical Education and Industrial Training. Adding to the list of achievements of Dr. Bharat, he is also the editor in UILS Law Review. His achievements have been recognized by many different awards, including the SS National Award for 2 consecutive years. Thank you so much, sir, for bestowing us with your presence. I would now request our panelists to permit us to commence this section.
Thank you, panel.
Now, we shall commence with our first session. All the speakers shall be provided with 3 to 5 minutes for their presentations.
The first speaker for today's session is Mr. Sumit Sharma from St. Wilfrid's College of Law, Jaipur. Mr. Sumit Sharma from St. Wilfrid's College of Law, Jaipur.
I think Mr. Sumit is not here with us right now. So moving on to the next presenter, Ms. Aarti Gautam from Netaji Subhash University, Jamshedpur. Ms. Aarti Gautam from Netaji Subhash University, Jamshedpur.
I think she is not present with us. So moving on to the next presenter, Ms. Savita Pawar from St. Wilfrid's College of Law, Jaipur.
Moving on to the next presenter, Ms. Rubina Khan from Maharaj Vinayak Global University, Jaipur.
A woman is the full circle. Within her is the power to create, nurture, and transform. Good morning, dear friends, esteemed dignitaries. I, Rubina Khan, stand before you to present the paper on demystifying the socio-legal aspects of women's reproductive health. Every person has a human right to the highest attainable standard of physical, mental, and emotional health. A healthy reproductive and sexual life is a human right. Before delving into the issue, let's understand the meaning of reproductive health as defined by the 1994 Conference on Population and Development at Cairo as a state of complete physical, mental, and social well-being, and not just the absence of any bodily disease or infirmity. The reproductive rights of women give her the ability to live with dignity, to be able to control her reproductive life, the right to choose their preferred methods of family planning, and with accurate health care information to lead a healthy and fulfilling life. And when a woman is denied this right, she is denied her right to life, health, and her human right. Undeniably, the women's rights to reproductive health have been recognized on national and international levels as an integral part of the human right. Internationally, reproductive rights are included in the UN human rights treaties and conventions, pointing towards the obligation of the state to protect, promote, and fulfill the rights related to reproductive health. The Universal Declaration of Human Rights, its covenants have reference of reproductive rights, including the rights such as right to life, right to privacy and family planning, right to non-discrimination, etc. And talking of India, which has made a considerable progress in the economic, social, and political aspects in recent decades, the reproductive rights of individuals can be located in constellation of laws and policies relating to health, employment, education, food, and nutrition. The Constitution guarantees certain fundamental rights such as right to life, right to equality before law, the right against non-discrimination, and the right to freedom and expression. Several provisions of directive principles in the Constitution are also related to issues of health, such as Article 47 stating to raise the level of nutrition and the standard of living of its people. Article 39E directing the state's policies towards the workers' health. Article 42 requiring the state to ensure just and humane working conditions for the workers and maternity relief. A significant piece of legislation, speaking of this, is the Medical Termination of Pregnancy Act 1971, which legalized abortion, and to support the reproductive rights and gender fairness, the Union Cabinet increased the upper limit of the medical termination of pregnancy for women from week 20 to week 24 in the January 2020. Another legislation is the Preconception and Prenatal Diagnostic Techniques Act 1994, enacted to prevent the misuse of preconception and prenatal diagnostic techniques for determining and disclosing the sex of the fetus to the pregnant women or her relatives. While the Constitution does not specifically mention the right to health, various Supreme Court rulings have interpreted right to health as an integral part of right to life under Article 21. In Suchita Srivastava versus Chandigarh administration, Supreme Court held reproductive autonomy forms a part of women's right to privacy, dignity, and bodily integrity. Recently, in the Puttaswamy judgment, the Apex Court explicitly affirmed women's fundamental freedom to make reproductive choices as a part of personal liberty under Article 21. These judgments have an important bearing on the reproductive rights of women, which are fundamental to the realization of all human rights. When we talk about the data, having analyzed various records, it's saddening that in India, one woman dies every 15 minutes due to health care during the pregnancy and childbirth, and another dies every 3 hours due to an unsafe abortion. In addition, according to the Special Bulletin on Maternal Mortality Rates, recently in 2022, India's maternal mortality rate has improved to 103 in 2019 from 113 in 2018. Still, 7 Indian states have the highest maternal mortality rate, including the state of Rajasthan. Considering this, Government of India has launched many initiatives, namely Sishu Suraksha Karyakram for pregnant women, Kasturba Poshan Yojana to facilitate adequate nutrition during pregnancy, and most importantly, Suman, Surakshit Matritva Ashwasan, with an aim to provide assured, dignified, respectful, and quality health care to every woman and newborn visiting the public health. To summarize, I'm reminding of one famous slogan, healthy women, healthy world, embodies the very fact that the women represents the cornerstone of family's overall health. It is responsibility of our nation to have a well-developed public health system that is capable of providing a good quality health care, which is accessible to all, and above all, which is accountable to all the citizens. A holistic, comprehensive, and life course approach beyond reproductive health is needed to achieve the overall health of the women. At the end, I would like to say, just as a bird could not fly with one wing only, the nation would not march forward if the women are left behind. Thank you.
Now, I would like to invite our next presenter, Ms. Bhanavi Saxena and Ms. Mudita Sharma from Mody University of Science and Technology, Lakshmangarh.
Good morning, everybody. My name is Mudita Sharma.
And I am Bhanavi Saxena.
And we are students of Mody University School of Law. Today, we would like to present our research on the topic, choice of women with regards to abortion. We are going to focus on the lacunas left behind in the Medical Termination of Pregnancy Act 1971 and suggest measures for the same. I would like to begin with the famous quote by Margaret Sanger. No woman can call herself free who does not control her own body. Women's control over their own childbearing is a key component of reproductive rights. For women in countries, abortion is often a choice that is derived from lack of alternatives, and it is important to ensure that women's basic need for access to appropriate contraceptive options is addressed, along with the need of safe abortions. Article 21 of the Constitution of India includes within its ambit an aspect of right to life and personal liberty through right to reproductive choices, and abortion is one of them. The Medical Termination of Pregnancy Act 1971 enabled termination of pregnancy by a registered professional of medicine, which can be seen as a more liberal ideology in terms of abortion rights. But policy making and advocacy efforts have not always addressed the full range of factors that are critical in defining women's options on reproductive matters. The evolution of abortion begins when there was a shift to liberalized opinion on abortion in 1960 and 1970 across Europe and America, and its effect could also be seen in India when Shah Committee was appointed to evaluate the social, cultural, legal, and medical phases of abortion due to high maternal mortality rates and unsafe abortions. Women have limited decision-making power, which also means that influential family members play a significant role in women's ability to get abortion. A question, therefore, essentially arises that why opting for termination of pregnancy when there are alternatives available, say contraceptives? The response might be due to women's lack of understanding about safety and reversible contraceptives, or lack of information available through government family planning programs, or both. However, large portions of women in India lack not only access to safe abortion, but also access to safe and effective contraceptions. The reproductive rights are to be realized. It is important to ensure that women's basic need for access to appropriate contraceptive options is addressed along with the need for safe abortions.
The MTP Act provides that to terminate a pregnancy, it must be conducted by a registered medical practitioner under specific circumstances, like when the pregnancy proves to be a risk to the life of the mother, or if the child could have potential to cause grave injury of both mental or physical to the mother, or if the child suffers from fetal abnormalities. It also duty bounds the medical practitioner to maintain confidentiality, since abortion is a personal matter to the mother. But the key point of criticism is that, howsoever detailed the legislation be, the primary focus of the special legislation should have been women, but it presents women as a beneficiary and the medical practitioner and the state as the stakeholders. This legislation has made it clear that India is in the want of major developments in her abortion policy. Secondly, the MTP Act was not made with a vision to provide reproductive rights to women. Rather, the aim behind this legislation was to control population, therefore portraying a failure to provide a women-sensitive legislation. The MTP Act 1971 also provides the doctors referring to women seeking abortion to medical boards, which was not a feature in the old legislation, yet it was highly criticized due to being patriarchal and restricting women's freedom of choice. And in the Amendment Act 2021, this feature unfortunately has been a permanent procedure. Women who are diagnosed with fetal abnormalities and who have crossed the pregnancy limit of 20 weeks as per the old legislation, and as per the new legislation it is 24 weeks, have to seek permission of the court through writ jurisdictions to terminate the pregnancy. This was a major point of criticism by the various NGOs, but it still has not been included in the Amendment Act of 2021. Therefore, if I conclude my words, abortion is one of the most controversial issues of the contemporary times, and it is a reproductive health service that can play an integral role in the lives of women, couples, and even communities. A strong recognition by judiciary of reproductive rights as fundamental rights has created a mandate for the government to move from population control strategies and confronting discriminatory stereotypes that limit women's authority, and instead prioritize women's right to dignity, autonomy, and bodily integrity in reproductive health services. However, the progressive approach as anticipated from the Amendment Act of 2021 is not fulfilled, as the Act continues to be insensitive to women and portraying women as beneficiaries rather than the actual stakeholders. Thank you so much.
Thank you so much, ma'am. Now, I would like to call our next presenter, Ms. Palash Bhargav and Ms. Shruti Changotia from Mody University of Science and Technology, Lakshmangarh.
Good morning to one and all present here.
I, Shruti, and Palash are here to present the paper with the title Women and Education. This paper deals with the status of women education from past till today.
It is rightly said by Pandit Jawaharlal Nehru that if you educate a man, you educate an individual. But if you educate a woman, you educate a whole family. Women education plays a critical role in society. Men and women are the two wings of bird flying high for the success of nation. Education helps women to be empowered and contribute in the growth of family, society and country. Better education for women also helps in proper healthcare and family planning in society.
In many countries like France and Britain, women got the education right very late, that is 1848 and 1868 respectively. But in India, women had their educational rights since the Vedic era, that is very beginning.
At that time, women had right to pursue Vedic education as per her choice. Many female intellects and sages like Atri, Gayatri, Gargi, Indrani were active in educational programs and discussions during that period. But as the post-Vedic period arrived, women education started declining. In some areas, women were denied educational rights and forced to do the household work.
The situation got worse when the external forces invaded India. Indian women were restricted from going out of the house and Parda Pratha was also emerged. Due to this, women's educational right was seized. Only women from royal and wealthy families were allowed to go out and take educational rights from the personal tutors.
But British era became a dawn for women. British government made laws which were in the favor of women. During the same period, social reformers like Jyotirao Phule, Swami Dayanand Saraswati, Raja Ram Mohan Roy came forward for the education and development of women. Many girls' schools and missionaries were established and girls were sent out for education. Women also participated in freedom movement of India and some played a major role in freedom and helped in formation of constitution.
The leaders of independent India very well knew that the development is only possible when women are developed. The Constitution of India since the very beginning provided equal rights of education to women and government also provided provisions for reservation to women in all the sectors.
There are many schemes like Sarva Shiksha Abhiyan, Beti Bachao, Beti Padhao, Balika Samriddhi Yojana, which are provided to the girls going to school. In India, Parliament also enacted Right of Children to Free and Compulsory Education Act 2009, which makes compulsory education for children aged 6 to 14. With all these and other measures adopted by government, the literacy ratio of women has reached 70% in 2021.
When it is compared with the literacy rate that is in 1901, which was 0.7%, it shows that women has come a long way. The enrollment of women in primary education is more than that of boys. Women represents themselves in all the fields and contribute in the development of nation. It is rightly recognized that women can contribute 770 billion in Indian GDP if equal opportunities are provided to them.
Yes, definitely. The education for women is getting better. But deep down in remote areas, there are girls who do not have access to education. Social backwardness, unawareness about education, and the stereotypical thinking is still a shackle for the growth of women. The government organizes various programs in rural areas and try to provide more opportunities to women in rural areas.
Today, women are lawyers, doctors, engineers, politicians, and everything we can count. From Carolina Sowarji, the first female graduate in India, to more than 13.75 lakh girls pursuing the education at present. India has marked a victory in women education.
We conclude by saying that we have achieved a milestone in women education, but still there is a long way to go. Malala Yousafzai, in one of her speeches, said that two powerful weapons in the world are sword and pen, but something which is more powerful is an educated woman. Thank you.
Our next presenter is Ms. Astha Parekh from Mody University of Science and Technology, Lakshmangarh.
Namaskar everyone present here. Myself Astha Parekh and I'm a student of LLB second year from Mody University of Science and Technology. Today I'm here to present my paper titled as Status of Women Under International Law, Real or Fictitious. I'll be discussing how the condition of women has changed from the past along with the implementation and introduction of mechanisms introduced and their effect on the condition of women. As it is a very vast topic and inclusion of everything is quite difficult, though I have tried my best to show the clear picture. So if you go some decades back, when women had same equality as that of men and were treated as goddesses with respect and proper integrity. This sounds like a fairy tale in today's time, but this was the absolute truth. With the passage of time and change in the social, political, and economic aspects, women lost their statuses and were camouflaged to the background. Women lost their right to education, right to vote, right to live in a free environment, and along with other fundamental rights which a human being gains right after their birth. The world started to change into a men-patriarchal society, and evil customs and traditionals started to grow against women. Violence such as rape, physical and mental harassment, female infanticide, sati pratha, etc. started to grow, which led to the declining of gender ratio around the globe. Women were treated as slaves and were only restricted to their homes. Violence against women started to increase and safety became a bigger concern. Even they were not safe at their homes, around their closed ones. I want to quote two lines here that, कहता है महफूज रहे वो मेरे घर की बंद दीवारों में, बता द्रौपदी कहाँ लूटी थी घर में या बाजारों में. All these were increasing day by day, and international organization came into the frame and started working for the elimination of the social evils. Since the founding of UN, equality between men and women and with the elimination of all the sort of discrimination has been the most fundamental guarantee of human rights. The United Nations aims to promote respect for human rights and fundamental freedom without discrimination of race, caste, language, or religion. Now, moving forwards, let's discuss about the mechanisms laid down by the international law for the protection of human rights of women. Universal Declaration of Human Rights, or more popularly known as UDHR, adopted in the year 1948, which was adopted using the term all human beings and everyone, in order to leave no doubt that Universal Declaration was intended for both men and women equally. In addition to this, Commission of Human Rights began to draft two human rights treaties, International Covenants on Civil and Political Rights and International Covenants on Economic, Social and Cultural Rights. Together, these three are known as International Bill of Human Rights. Article 2 and 3 of these covenants prohibits gender discrimination and ensures equal rights of men and women to the enjoyment of rights contained in them respectively. Moving forward, in the year 1967, the General Assembly adopted a declaration on elimination of discrimination of women, which stated that discrimination against women is an offense and called on the states to abolish existing laws, customs, and practices which were discriminatory against women. Later on, after some years to this declaration, in the year 1979, General Assembly adopted another convention which was more stricter and powerful, named as Convention on Elimination of All Forms of Discrimination Against Women, or more popularly known as CEDAW. It contains 16 substantive articles, and its preamble stated that despite of existence of other instruments, women still do enjoy equal rights with men. Some more conventions were adopted, such as Convention on Nationality of Married Women, which protect the nationality of women after and before the dissolution of their marriage. Another convention named as Convention on Political Rights of the Women, which protected the political rights of the women, which led them to vote to choose the representative of their own choices. Many conferences were also organized around the world, and the most important and the scene changer was the Beijing Conference in the year 1995. In this conference, 12 critical areas were discussed, and as the increasing burden of poverty, educational opportunities, inequality of health status, and violation of human rights against women were discussed. So now moving towards the conclusion, it can be stated that various steps has been taken around the globe
to improve the status of women. It is justified that because of these steps, the condition of women has changed and it is appreciable from the last 2 or 3 decades. By comparing the scenario, it can be stated that neither the development of women is real nor it is fictitious, as many things have changed and got better from the past decades, but still some rules and laws are only printed on the papers. For achieving the equality, the society has to change and develop their minds, because violence and discrimination against women is not only a legal problem that can be controlled by legal necessary remedies. It is more of a psychological problem and can be eliminated by the fundamental changes in the society. So, the objective of my paper is to make women aware about the rights provided to them, to change the thinking from औरत है, लड़की है, ऐसा ही होगा, to I am a woman, I stand for my rights. Lastly, I thank you all for the precious time by saying that we all have to work hard and make this world a better place for women to live and growing. Thank you so much.
Thank you, ma'am. Now I would like to call upon Ms. Garvita Chaudhary and Ms. Mahima Saraswat from Mody University of Science and Technology, Lakshmangarh.
My body, my choice. Unhealthy embryo versus dignity of life. Mother's choice. But what about life of a fetus?
Good afternoon to one and all present here, respected dignitaries, teachers, and my dear fellow mates. We are going to present our paper on the topic reproductive right, a need, a choice, or an individual's right. India was in first few countries of the world to legalize abortion services to women who need to terminate pregnancy due to certain therapeutic, eugenic, or on humanitarian grounds.
September 1964 was the first time when Central Family Planning Board put it up a Shanti Lal Shah committee and legalized the concept of abortion.
In the last 1 decade, several writ petitions have filed before the Honorable Supreme Court and in various high courts,
seeking permission for aborting pregnancies at gestation age. This need was because of the abnormalities of child or sexual abuse on women.
The Medical Termination of Pregnancy Act is a step towards safety and well-being of a woman. Safe and legal abortion provides enlarged ambit for women.
Conditions under which abortion can be done bona fidely are therapeutic grounds. If continuing of pregnancy causes injury to the mental or physical health of women, and when it is immediately necessary to save the life of a woman.
Then on the humanitarian side, pregnancy causes due to rape and incest, and on social side, there are several contraceptive failures too.
But we can't deny a fact that one of the main reasons for illegal abortion is female feticide.
And when there is a liberty, there are certain reasonable restrictions too. And PCPNDT Act is one of the bona fide restriction on such practices.
क्यों जन्म लेने से पहले ही नामो निशान मिटा देते हैं लोग? क्यों जन्म लेने से पहले ही नामो निशान मिटा देते हैं लोग? अपनी खुशियों की खातिर गहरी नींद सुला देते हैं लोग.
Prenatal diagnostic techniques were available since 1970s, but there was only partial ban as it was prohibited only in government hospitals. In 1988, Maharashtra was the first state to ban PNDT techniques.
And as we all know, Punjab, Haryana and Rajasthan are one of the major sensitive states for female feticide. But between 1988 to 1994, these states also passed laws on banning sex determination.
You all should know the main aim of PNDT was of detecting genetic disorders, metabolic abnormalities, and sex-based disease. But instead of using it as a boon, our society made it as a curse on female girl child.
Terminating a pregnancy for a woman to make a decision is mentally, emotionally, and a very physically impacting decision that she takes in her life. And for her, who is at an advanced stage of her pregnancy and a stage where she knows that there is a life inside her womb. For her to take that decision is a difficult one indeed. For her to run across the two various medical boards is extremely demeaning to her, is invasion to her privacy and invasion to her choice. It's not a right-based approach, it's a need-based approach.
Interaction of PCPNDT Act with MTP Act is an assumption that second trimester abortions are the result of sex determination causes concern. Due to fear of PCPNDT authorities, many private practitioners are refusing to provide abortion facilities, especially during second trimester. Private medical practitioners also denied abortion to unmarried girls, single women, and for pregnancies caused by rape, for fear of inquiry jeopardizing their practice.
After considering all these major concerns for making the link of PCPNDT and MTP Act, there should be a proper check and balance to safeguard the right of abortion and taking care of prenatal life too.
We end with a note by Pamela Madsen that reproductive freedom is not just the ability not to have a child through birth control, but its ability to have one if and when you want. Thank you so much.
Thank you, ma'am. Our next presenters are Ms. Khushi Harlalka and Ms. Muskan Jajo from Mody University of Science and Technology, Lakshmangarh.
You can tell the condition of a nation by looking at the status of its women.
Good afternoon, everybody. I am Muskan Jaju.
And myself, Khushi Harlalka,
And we are here to talk about the role of judiciary.
in women justice.
One cannot imagine the magnitude of empowerment the judiciary invests in the women of the nation, making it one of the most essential tools of today's mankind.
We all know that both men and women faces criticism in order to attain justice. However, it is often seen that women faces extra criticism in attaining justice,
Which is the reason why we put a major emphasis on the role of judiciary.
and the aid it brings to women to overcome all the additional obstacles and attain justice.
To solidify the grounds of our claims, we present and analyze all the landmark cases which we felt in which we felt that the judiciary has played an important role.
We'll begin with the case of C.V. Muthumma versus Union of India in the year 1979. Countless laws have been made for ensuring gender equality in India. Even the Constitution of India provides gender equality. Both men and women have equal rights. Despite this, gender discrimination prevails. But contrary has been seen in the following cases.
In the case mentioned by my partner, it makes one wonder whether Article 14 and 16 is a myth or reality. It shows that how C.V. Muthumma was treated in a discriminatory manner when she was not promoted due to her gender. In this case, the petition was dismissed, but the judiciary worked towards this problem, which was clearly seen in the case of Air India versus Nargis Mirza in the year 1981.
Sabrimala case 2018. Young Indian Lawyer Association versus State of Kerala. In this case, it was held that devotion cannot be subject to gender discrimination. Women of menstruating age are not allowed to enter temples. It is irrational and unconstitutional and violates the Article 14, 15, 21 and 25 and said that women should be allowed to pray at the place of their choice.
Judiciary has always tried to empower women by carefully implementing the laws that were made for them. But what if there is no law? The following case, Vishaka versus State of Rajasthan in the year 1997, is a clear example of it. The mentioned case deals with the sexual harassment of women at workplace.
Nirbhaya rape case 2012. We all know about this extremely barbaric and heinous rape case. It generated a whole new set of laws for women, its protection against rape, further solidifying the foundation of the prior laws concerned with rape.
In the case of Independent Thought versus Union of India in the year 2017, the question was whether sexual intercourse between the man and his wife between the age of 15 and 18 amounts to rape or not. The court resolved the contradiction between IPC and POSCO Act by raising the age of consent to 18 years for marital sexual intercourse in order to preserve and protect the human right of married girl child.
Tukaram and another versus State of Maharashtra custodial rape case in the year 1979. In this case, the judiciary would have clearly taken a better course of action in delivering justice to the aggrieved. It was insensitive to the concept of consent before sexual intercourse and failed to recognize that the incident occurred was a clear example of rape.
Throughout this paper, we analyzed how judiciary has provided judgment in the cases that challenge the basic norms and morals of society.
This case puts the judiciary in a difficult spot that tested its efficiency at providing justice.
Yes, we can say that there were cases where the judiciary could have taken better courses of action, but we cannot defeat the fact that it tried its best to provide justice.
As we already know that when it's come to seeking justice or remedy for the violation of rights of women faces extra criticism.
This is the reason why in every court judgment that relates to right of women, it becomes of great social value and significance.
The verdict of judiciary in this case is not only warns of those who tends to undermine the dignity of women, but also empowers women and allows them to nurture their faith in our justice system.
After researching multiple landmark cases, we come to conclude that despite serious hurdles, the judiciary has always done its best efforts to impart justice and equality.
So yes, it would be safe to say that judiciary did and still plays a very essential role in providing justice to women and always tried to provide gender equality and gender justice, besides the conservative and patriarchal society that acted against it.
The Indian judiciary, through its judicial decisions, has always shown that discrimination against women won't be tolerated at all.
The judiciary has brought and is still bringing important and major changes in society by supporting equality and justice.
At last, we can conclude by saying that the judiciary has brought influential changes in the society by changing the narrow mindset of people. Thank you.
Thank you.
Now, I would like to call upon our next presenter, Ms. Manasvi Oja from Mody University of Science and Technology, Lakshmangarh.
For every crime against women, there is a society. For every crime against women, there is a society which portrays victims as criminals. Good afternoon to all the excellencies presented here. I am Manashvi Oja of SOL first year, and I am going to present my research paper on the topic of women and criminalization system in India. Crime against women is an indicator of the generally inconsistent power relations among people, which have prompt control over men by various issues, and to anticipate of women's full progression in all social orders like social agitation, culture, etc., are the normal indicators of brutality against women. However, the most preserving force of women's pride and security are social powers, pointed toward protecting male strength and female suppression, frequently protected by the sake of the respected custom. Brutality against ladies or females, although it's happened from the life cycle, and it gets basically started from the social life. The destructive impacts of certain customary or standard practices and all the demonstration of radicalism connected to race, sex, language or religion that certains the lower status agreed to ladies in the families, the working environment and the local areas, society, etc. In emerging nations, there are several practices against females, women's in the countries are frequently perceived and safeguarded as strengths of the social waves. Spouse beating, for instance, is reviewed as a component of normal thing in the numerous nations, a mainly privilege celebrated in various nations, and it can be convicted in numerous social orders. The right of spouse to beat or truly threaten his better half is profoundly held conviction in the numerous social orders. In need, females frequently viewed as specific measures of the actual maltreatment, advocate under specific circumstances. Legitimization for people seeing someone independent from the danger of provocation, battering, and rape is an idea that most women are struggling with envisioning since brutality against themselves. A large number of people who execute brutality feel advocated by the social culture messages that says that assault, battery, viciousness are satisfactory. Pictures in media of brutality against women, those that portray assault or sexual objection or subjection, as well as the utilizations of ladies and young ladies as sex object, including erotic entertainment and factors, adding to the precedent preservedness of such brutality unfavorable effective the local area at the large. The valued womanhood, which has been lended or lauded for a long, has been dissolved away with the flooded of unfamiliar and present-day culture. Throughout the long-term common pursuit have involved and boosted extent because of which the conventional culture is shrinking ceaselessly. The joy and the comfort in the family has been grabbed away by behaviors like torment, brutality, etc. Indeed, even the female incipient organism is exposed to desperate torment. The right of female kid is generally marked like hazardous. For having brought into the world as the female youngster itself is considered revealed by certain area of general public. As you know that there is only 972 females for every 1,000 males in 1901, while the figure there are just 972 young ladies for every 1,000 young men. In few Indian states like Punjab, etc., there has the low proportion of females over every young man. You know that the brutality against women are increasing day by day, and it in several areas it reported, but in several areas it is unreported. Why it is unreported? Because we have our efficient legal system and they are protecting us with their several protections. But we have lack of evidences and lack of issues in that system by which we are not getting the proper justice. Thank you.
Our next presenters are Miss Khushi Harlalka, Our next presenters are Miss Ritika Jain and Kratika Sharma.
Namaskar everyone. We are here to present our paper, and the title of our paper is The Social Dimension of Modesty. Modesty is very complex character trait, but generally most of the people feel that they understand and recognize what modesty is. But it is very difficult to understand. The word modesty is nowhere defined in any legal provision, but this offense of outraging the modesty is defined under section 354 and 509 of IPC, which provide an elaborative and comprehensive explanation of these sections. And in several cases, the Supreme Court had laid out the expression which is determined on the basis of facts and circumstances. In state of Punjab versus Major Singh, the Supreme Court provided that modesty is viewed as an attribute of human female, and also addressed substantive question that whether the modesty of 7.5-month-old female child can be outraged, and the court addressed it affirmatively. Generally, we all are evident with the situation where a man performs such acts with the end goal to outrage the modesty and ensure that such act is capable to shocking the sense of decency of that woman, due to which the woman suffer from actual and mental pain. But can a woman outrage the modesty of another woman? Yes, the answer is yes, because under section 354 and 509 of IPC, it implies gender neutral law. It says that not only a man, but a woman can also outrage the modesty. The expression, whoever incorporate that man and woman both can outrage the modesty of another. In many situations, we fail to understand the slim difference between the outraging the modesty and attempt to commit a rape because of the thin line of difference and due to its ambiguity. In every criminal act of rape, an attempt include indecent act of the accused. And where an attempt to commit an offense, the act of the accused must have proceeded beyond the stage of preparation, otherwise the person will be convicted for indecent assault but not liable under section 376, read with section 111 of IPC.
Developments are being made regarding the sexual offenses towards women. There are innumerable modifications which are brought in section 354 of IPC. On January 2013, Justice Verma Committee report was submitted. According to this committee, non-penetrative forms of sexual contact, also considered a sexual assault. The offenses committed against a woman need to have a quicker and speedy trial. This particular report plays crucial role, and through this many amendments were made in IPC. Its major amendments are section 354A, B, C, and D, which are sexual harassment, intent to disturb a woman, voyeurism, and stalking respectively.
In recent judgment of Delhi High Court, which took place in 2014, has ruled that showing middle finger to a woman amounts to outraging her modesty. The present scenario of society has been related to the legal instance. It is a responsibility of a man to prove his guilt that he is innocent. In a case of Lalita Kumari versus government of UP, it was held that if a woman wants to file the FIR against male, it is a duty of the police officer to register it without denying. In contradiction to women's exploitation and abuse of law, it has been noticed that large number of cases remain unreported and women suffer throughout their lives. There is need to bring change not only to protect but also to prevent their misuse. So at last, we are concluding this paper with some suggestions also. We suggest that before implementing any law that challenges the cultural stereotypes, the members of society should know about the legal provision through education, so that when they perform any act, they think twice. Nowadays, cases against women are increasing and cause emotional pain. The Justice Verma Committee gives certain recommendations for gender-neutral laws so that misuse can stop and true equality can be achieved. A law may be very well written, but it will mean nothing when implemented poorly. Government needs to make some changes so that more women come forward to report their offences, which will help in better implementation of the laws. Thank you.
Thank you, ma'am. Now, I would like to call upon our next presenter, Dr. Ela Gupta from Mody University of Science and Technology, Lakshmangarh.
Namaskar everyone, respected Dean Sir, guest faculty members, students and everyone. My name is Dr. Ela Gupta and I'm here to present my views on the national seminar theme, and the title of my topic is Global Perspectives on Feminism, Women Rights as Human Rights. One is not born a woman but becomes one. The social construct makes woman a woman, and women and gender studies are significant areas of academic inquiry today and has emerged as an interdisciplinary area of study worldwide in response to the need of our. While an awareness regarding women's questions and concerns under the representation or marginalization, misrepresentation of women's perspectives are not recent phenomena, the women's movements of 19th and 20th centuries have certainly fueled the need for creating more equitable societies for women and men worldwide. Additionally, a growing critical awareness about women's place in society during these times led to a sharp interest in researching and delving deeper into the specific experiences and subjectivity of women. Women's movements in the 20th century had made major headways in raising awareness about and addressing the marginalization of women's views and concerns in various arenas. Critical and theoretical academic discourses regarding these subjectivities began to be reflected in literary and cultural studies, philosophy, social sciences, art, film media, ecology, sciences, and other areas. The study has challenged the perspectives of all, to the marginalized groups, to the caste, class, race, religion, or sexuality. This is explained to address gender issues in relation to other inequalities, and this has led to raise the question of inequality among genders, races, and queer groups also. So they had also begun to interrogate normative lifestyles, sexualities, and perspectives. Here I want to add, when we say that this is women's rights are human rights, I also want to add that the queer rights, the third gender, and every living being, basically all rights are for human rights, emphasizing the idea when we say feminism, it is not just for women, it means equality for everybody, a right that exists for a human being. In India and other colonized nations across the world, the women's movements in its inception was closely associated with the nationalist and dissidents against imperialism movement, as well as with the interrogation of other kinds of social ceremonies. The Dalit movement and the rights or struggle of peasant Dalit feminism, black feminism and economic feminism are intertwined, and it is a sad, pathetic sight to see that economic feminism has taken a toll on the whole society. The liberation analysis in the light of social constructions of sexuality and their impact on definitions of gender, organized attempts towards greater equality and issues of legal and constitutional rights. Women's roles and their spaces in patriarchal societies as a challenge it has been a challenging question. Feminist theories have helped to dismantle and deconstruct these knowledge systems. The paper examines in detail some of the work done by feminist theories in bringing about constructive critiques of knowledge in the natural sciences, social sciences, and human sciences. The feminist, I just have 1 minute left, so I would want to sum up. Coming to the 17th, 18th, and other centuries women writers, and straight away talking about Mary Wollstonecraft's work, The Vindication of Rights of Women. It got published in 1792, and it echoed in France, USA, and it said about women's desire for liberty and equality. After Mary Wollstonecraft, we see even Margaret Fuller's her works. She has also given some significant works, women's education reform, extended her concerns with gender roles and unequal power. Then we come across Virginia Woolf. She talks about again, the concept of androgyny and authorship and the importance of women's personal space in a room of one's own. Simone de Beauvoir speaks about the existential feminist, which is quite common these days in the second sex, and she talks about long justification of women by men in society. Othering, we call this process. She's seen as inferior to men, that in the social construction of gender. The time is up, and I just wanted to talk about the rights that, the problems that women or human beings are facing, and a few solutions to that already exist, but we just need to talk about the execution. But any which way, we have spoken and we have heard today great speakers, and yes, it has been kind of covered also. So I'll sum up. It's right now, women and young girls everywhere face an immense range of challenges, from inability to access food, education, employment, or to the threat of gender-based violence. Their perspectives and experiences must shape our collective future. I think this should be the objective, which is quite human and which is good for the humanity and all of us, the man, women, and the third gender too. Thank you.
Thank you, ma'am. Our next presenters are Ms. Garima and Ms. Isha Singla from Mody University of Science and Technology, Lakshmangarh.
Good afternoon, everyone. Today we are here to present the topic, Equal Opportunities for Women in Employment Sector, a Myth or Reality. As we all know that we are in a women's university. Here all girls are getting an opportunity to make their dreams come true. What we mean by dreams here is to gain financial and social independence. Education is one of the major means to get employment, and employment can give us the desired financial independence. So through this article, we tested whether equal opportunities in employment sector have been ensured or not. Last year, the Supreme Court allowed girls to appear for NDA examination after class 12th. This is a very good example to tell that women are provided with equal opportunities as men, but what about those girls who were subjected to discrimination on the sole basis of gender prior to this judgment?
Yes, I do agree. I was also a non-medical student in my class 12th. I wanted and still want to join Indian Army. Earlier, I was not allowed to give ND exam just because I was a girl. Clearly, that was gender discrimination. But I didn't do anything. I just accepted it as it was a law. But you know what? If we, as women, want to get equal opportunities as men, then we should know how to raise our voice, as Mr. Kalra did by filing a writ petition for NDA exam. This clearly shows that equality is not given, it is taken.
But yes, we do agree that our judiciary is trying its hardest to provide us with the equal opportunities, but it cannot provide us justice until we speak for ourselves.
Yes, there is a saying in Hindi, प्यासा कुएं के पास जाता है, कुआं प्यासे के पास नहीं आता. Same applies here also. Judiciary can give us justice, but only when we raise our voices loud enough to grab their attention.
Concludingly, we can say that the dream of equal opportunities for women in the employment sector is turning into reality day by day, provided that
we do raise our voices. Thank you. मुझे एक छोटी सी बात और कहनी है. अभी थोड़ी देर पहले एक क्वेश्चन उठा था कि वुमेन आर ह्यूमन, तो वुमेन को अलग से राइट्स क्यों मिलती है, उनको ह्यूमन राइट्स में इंक्लूड क्यों नहीं किया जाता है. हम इंडिया में रहते हैं और इंडिया एक मेल डोमिनेटिंग सोसाइटी है, जहां पर वुमेन को पैदा ही नहीं होने दिया जाता था, वहां पर इक्वल अपॉर्चुनिटीज की तो बात ही दूर थी. ये हमारी कॉन्स्टिट्यूएंट असेंबली बहुत अच्छी तरह जानती थी. इस वजह से उन्होंने 15(3) में स्टेट को ये पार दी कि वो स्पेशल प्रोविजंस बना सकते हैं वुमेन के लिए. तो मेरे ख्याल से ये क्वेश्चन अब क्लियर हो चुका होगा कि मेन को हम क्यों उनके लिए स्पेशल राइट्स नहीं बनाते और वुमेन के लिए क्यों बनाते हैं. थैंक्स.
Thank you. Now I would like to call our next presenter, Ms. Disha Joshi from Mody University of Science and Technology. Ms. Disha Joshi from Mody University of Science and Technology. I think she is not present with us right now. So moving on to the next presenter, Ms. Yashashvi Shekhawat and Jyoti Rathore from Mody University of Science and Technology.
Women rights, men rights, and human rights all are threatened by ever-present spectre of war, so destruction. It's important to take charge of our destinies as women. We have voice and choice. A very good afternoon to esteemed dignitaries and all-in-one present here. I, Yashasvi Shekhawat with Jyoti Rathore, and the subject of our presentation is Shielding Women's Human Right During Conflict and Crisis. Women are entitled to same general protection without discrimination as men during conflicts, be it as combatants, as civilians, or persons, hors the combat.
No one can escape the devastating grip of war. For women, it can mark a point of no return. During conflict, women are mostly portrayed as victims of conflict, and of course, to a large extent, they indeed are being targeted for rape, forced marriage, violence, torture, and suffer most from decay of social sectors. For too long, sexual violence was just seen as collateral damage of war, a random, private, inevitable byproduct of war. Zainab Salbi is an Iraqi-American activist, women's rights activist, and founder of Women International. On a trip to Eastern Congo, Shelby was interviewing a woman named Nabito, then age 52. Rebels had raped Nabito and 3 daughters. There were so many, she said. She could not tell how many had raped her. Many freedom fighters were ladies, fighting for justice, fighting for rights, fighting for good things. Women and girls pay the highest price during conflict, like the one in Ukraine. Gender-based violence affects at least 1/5 of women in Ukraine, with nearly 22% of Ukraine women between 15 to 49 years of age have experienced at least one form of physical, sexual violence in their lifetime. Women in Ukraine are not only fighting on the personal fronts, dealing with the social economic consequences of the conflict, but also on the front lines to defend the pride of their nation. Let us all do our best to end the conflict. Let us all put on a gender lens also to see how this conflict is affecting women and girls. And let us all come together to find a solution through negotiations and through peaceful means. And not forgetting to keep women at the table when we are negotiating this peace and when we are negotiating how we move forward. Thank you so much.
Thank you. Now I would like to call our next presenter, Ms. Ishika Agrawal from Mody University of Science and Technology.
Good morning, everyone. I have researched on the paper titled Cyberspace, an Incognito for Offenders. All women rights are human rights, a general truth in the eyes of law, but not a prevalent case in the case of cybercrimes. As the title says, cyberspace has become an incognito mode for offenders. Crimes in the virtual world are as heinous as the crimes in the real world. Since ancient times, women were victimized instead of being treated as divinity, as our Shastras say. According to National Crimes Report Bureau, in the year 2017, 4,242 cases were reported as of cybercrimes against women. And in the year 2020, the figure rose to 10,405 cases. We can see the spike. And again, I would like to mention it is not any increasing figure in the GDP that India should be proud of. Cybercrime is a criminal activity such as fraud, theft, or distribution of porn committed using computer, especially to illegally access, transmit, or manipulate the data. The research question is whether the existing laws needs amendment concerning cybercrimes against women. Online harassment is the abuse of a person by keeping an eye, humiliating, harassing, threatening in several forms like cyberstalking, voyeurism, revenge porn. A stalker may be right next to you, next door, a relative, or any stranger, boosted by the anonymity that the internet offers. A stalker's psychology is the most difficult to understand, but any intentions does not offer you a reason to harass somebody. Making sexual comments, publishing in things intended to defame a person, hacking one's computer, and monitoring the activities, email spamming, or wherever the devil's mind can lead to are all included in cyberstalking. Now see, it is as harmful as physical stalking. Even more, because you don't know even if you're stalked being right now. So, have you all heard about the boys' locker room incident that happened in the lockdown? No one could ever think of that the teenage minds could gather and form a group and share the obscene pictures and objectify women to such extent. These are the developing minds and the future of India. Objectifying women to this extent and discussing her in your group is not justifiable. The legal action was taken against them. After Nirbhaya gang rape case, certain amendments in the criminal law were made and the provisions for voyeurism and stalking were included in Indian Penal Code. Any person who watches, captures the image of a woman in her private space where she would not expect any act as such is voyeurism. In a blog that came in the year 2017, victims of revenge porn have said, "I grew suicidal. I completely destroyed my outlook about how future could be." And many more as such statements. Revenge porn, as the name is, it is the revenge of a person by either blackmailing to publish the explicit images or doing that act. The first case of revenge porn came in the year 2018, state of West Bengal versus Animesh Boxi. The court had ordered 5 years of rigorous imprisonment and a fine of rupees 9,000 to the offender. And it also made an interesting statement that the victim should be treated as a rape survivor because the harm that it does to the mental state of a human being is of the same level, and the adequate compensation should be provided by the government. Right to privacy, right to live with dignity is a fundamental right. Then why is it just snatched away in the world of cyberspace? Now, in our statutes, where does it mention about revenge porn? Nowhere. See how atrocious this crime is. And this should be a specific law. Laws that are women sensitive should be discussed. Those which protect the rights of the women should be made. Now the IT Act. IT Act talks about cyber crimes against women in one or two or three sections. But we see, when was this act enacted? In the year 2000. And when was the latest amendment made? In the year 2008. A whole decade passed after the amendment in the IT industry. Should the laws be this rigid and not flexible in this dynamic world where the IT industry is growing every day? This is the need to bring amendments in the law. To establish compliance with the fundamental rights that are enshrined in the Constitution. National Commission of Women have been established, and we all should feel free to report any such crimes against us. Objectifying women has become common for society, but please note that it is not normal, and women's rights are also human rights. Thank you.
Our next presenter is Mrs. Aditya Jain from Mody University, Rajasthan.
No nation can ever be worthy of its existence that cannot be take its women among with the men. No struggle can ever succeed without women participating side by side with men. A very good day to all. I'm Aditya. Today I'm here to present my paper, An Analysis on Women Victim Compensation, the Women Rights Approach. Women rights are an essential part of the overall human rights agenda trained on the equal dignity and ability to live in freedom all people should enjoy. No matter how rare it may be, women criminal victimization is significantly more harder than that of man. The rape and sexual assault of women is far more common than that of man. Violence against women and girls over 12 is a common occurrence in the United States. According to the most recent data, 1 out of every 6 women has been the victim of a rape or attempt rape. 8,070 rape occur each year. The majority of rape occur between the age of 16 and 24, when women are most vulnerable. If justice to be maintained, the state must sustain the judiciary foundation. Even if the perpetrator is not found guilty, the victim may still be entitled to compensate. The existing criminal justice system does not require the identification of a victim if the court rules that no crime was committed. Even if the court finds that an offense has been committed against an aggrieved complainant or victim, an offender accused may be acquitted or dismissed for one or more of these grounds. Traditional recompensation for women victims has been in place of decades. She advocates for victims to be given a fresh perspective of their situations and present with opinion, working on English correction reformer in 1950. As a result, in both the United States and Europe, government compensation program have been implicated. In India, criminal law in India is often linked back to countries colonial period under British rule and the organizer here by day. Section 357 of CRPC had a sustained effect on the law. It was decided to eliminate a substantial section in favor of 2 new ones. Although the sentence does not contain a fine, subsection compensation outline the jurisdiction and power of relevant courts. An order to granting compensation can be made if an associated tribunal, the tribunal or the court of session exercise its revision power. Women victim compensation funds. The State Legal Service Authority or District Legal Service Authority shall decide the amount of compensation to be granted to women victims or their dependents who have incurred loss or injury as a consequence of an offense and who required rehabilitation. Women Victim Compensation Fund will introduce the following. Donation of the CVCF scheme were made in 2015. Inclusion of SALSAR yearly budgetary allocations in the form of janitary aid, third cost imposed by civil and criminal tribunals for international, national, state or central government recompensation recovered from the perpetrator under clause 14 of the scheme. Now, I am concluding my paper, Victim Rights and Humanitarian Law. As part of our human dignity, we are all entitled to the freedom to existence our human rights. These rights, which are sometimes referred to as non-transferable as essential to human existence. One may say that they are all of these and more. The best protection any women can have is courage. Amazing thing happens when women help other women. Women are the real architecture of the society. Thank you for listening me and give me an opportunity.
Thank you, ma'am. Our last presenter for this session is Mahendra Kumar Sharma from Mody University, Raipur. Mr. Mahendra Kumar Sharma from Mody University, Raipur. I think he is not here with us right now. So, as all good things come to an end, we would request our chairperson, Professor Dr. Madhu Shastri, to end the session with her concluding remarks.
I would request Dr. Sushma Gaur to please come and enlighten us with the valuable words.
This must be.
Hello. Respected Dean Sir, all the dignitaries, respected मधु शास्त्री मैम, ये मेरा सौभाग्य है कि आज मैं मेरे गाइड के साथ बैठी हुई हूँ. सबसे पहले तो मैं आप सबको कहना चाहूँगी ये मेरे प्रेरणा स्रोत हैं. आप शास्त्री सर भी और मधु शास्त्री मैम भी. आज मैं जो कुछ भी हूँ या इनके आप लोगों के सामने बैठी हूँ वो सब इन्हीं की वजह से. आपका जो आज का टॉपिक था, सबसे पहले तो सभी स्पीकर्स ने बहुत अच्छा बोला, वेरी इंफॉर्मेटिव एंड प्रोग्रेसिव. आज इतनी सारी लड़कियों को देख के और गर्ल्स को देख के ये जो टॉपिक है ह्यूमन राइट, अपन मानव अधिकार की बात कर रहे हैं, तो मैं अपनी सोच के बारे में कहना चाहूँगी. अपन दो वर्ड पढ़ते हैं, ही और शी. तो जब शी में से एस को हटा दिया जाता है तो ही का निर्माण होता है. तो अपने अस्तित्व को कम आंकना कहीं भी सही नहीं है. अपना अस्तित्व था, है और रहेगा. रानी लक्ष्मीबाई को अपन देखते हैं, उन्होंने किसी भी अधिकारों की मांग नहीं की थी. अपने अधिकार चाहे और अंग्रेजों के टाइम में भी लिए. आज जिन जिन लोगों ने बोला, रुबीना मैडम, इला गुप्ता मैम, आदित्य जैन मैम, भैरवी, मुदिता, श्रुति, आस्था, गर्विता, उन सभी ने अबॉर्शन, रिप्रोडक्टिव राइट, ह्यूमन राइट्स सभी की बात की. तो मैं बात अधिकार तो अपन हर साल लॉ बनाते हैं और बनते जाते हैं और अपन सारी महिलाओं को मिले हुए भी हैं. बात सोच की है. अपन कहते हैं, पढ़ते आते हैं, बेटी बचाओ बेटी पढ़ाओ. मैं समझती हूँ होना चाहिए बेटा पढ़ाओ बेटी बचाओ. जब तक समाज में मानसिकता नहीं बदलेगी, पेपर के अंदर जितनी भी महिलाओं के विरुद्ध अपराध हो रहे हैं वो कम नहीं होंगे. आप बात कर रहे हैं ह्यूमन राइट्स की. मानव तो इसलिए जरूरी है, हाँ, मानव अधिकार तो इसलिए जरूरी है क्योंकि हमें पैदा होने का अधिकार ही नहीं दिया जा रहा. थैंक यू ऑल ऑफ यू.
Thank you, ma'am. Professor Shastri, Honorable Dean, School of Law, Mody University. Professor Dr. Madhu Shastri, Chairperson of the plenary session. Madam Dr. Sushma Gaur, Co-Chair. Esteemed officials of the Mody University. Guests present in the August gathering. Respected faculty members and my dear students, kindly accept my salutations for the eminence, elegance and excellence in you all. At the very outset, I appreciate and acknowledge the positive efforts of all the presenters who have raised all the pertinent issues. When we talk about the concept of women rights, that women rights are human rights, and we have a concept of equalitarian society. We want that on the basis of gender there should be equality in our society, right from the concept of UDHR to CEDAW, right from the concept of sustainable development goals to millennium development goals. we have one concept only, that माता का सिंदूर, बहन की राखी, बेटी की मुस्कान और प्रियतमा की पायल सुरक्षित होनी चाहिए. And it is in this backdrop only that we have the Sanskriti, Sanskar and Sabhyata, which talks about the concept of Yattar Naryastu Pujyante Ramante Tattar Devta. जहां नारी की पूजा की जाती है वहां देवताओं का वास होता है. अगर हम नारी की पूजा करेंगे तो हमें हर प्रकार की सफलता मिलेगी, हर प्रकार की तरक्की होगी और समाज में हर प्रकार की खुशहाली आएगी. इसी के साथ साथ हमारी संस्कृति, हमारा संस्कार, हमारी सभ्यता हमको बताता है धर्मो रक्षति रक्षितः. जो धर्म की रक्षा करता है, धर्म उसकी रक्षा करता है. आज ये धर्म शब्द जो है हम इसको रिलीजन के माध्यम से समझते हैं, परंतु धर्मो रक्षति रक्षितः में धर्म का सही अर्थ है ड्यूटी से, कर्तव्य से, कि हमारा क्या कर्तव्य है, हमारा क्या दायित्व है. जब हम राइट्स की बात करते हैं, अधिकारों की बात करते हैं, तो हमें कर्तव्यों की बात भी करनी पड़ेगी. बिना कर्तव्यों के हम अधिकार के बारे में कुछ नहीं कह सकते. एंड बीइंग अ स्टूडेंट ऑफ लॉ, I must say the rights jurisprudence is incomplete without the concept of duties. So if we as a human being, all of us, we are going to perform our duties, automatically the rights are going to be protected. As we have 3 organs, I understand lunch ka time hai, madam ne humko yaad dilaya. I am just going to sum it up. Just like we are going to take the instances of 3 organs, the legislature, the executive and the judiciary. Taking 2 instances from all these 3, the legislature has brought some kind of amendments in the IPC to protect, preserve and promote the rights of the women. We have come up with the concept of amendment in the Companies Act, new Companies Law, for the purpose of having the concept of women directors. On the side of judiciary, we have the landmark judgments of Vishakha versus State of Rajasthan, Joseph Sain versus Union of India, and on the side of executive, we have the concept of the Beti Bachao, Beti Padhao, the concept of toilets, Ujjwala Yojana, etc., etc. But if legislature, executive and judiciary, all of them, they are performing their duties and functions, the onus lies on us, the onus lies on we all. If we want to make my India, our India, your India as a rising India, shining India, glorious India, then we have to understand नारी शक्ति समाज की शक्ति है, समाज शक्ति राष्ट्र की शक्ति है, राष्ट्र शक्ति विश्व की शक्ति है. और इसी संदर्भ में सिर्फ एक छोटी सी बात बताऊंगा जो हमें अपने एज इंडिविजुअल करनी होगी. जब हम देखते हैं कि एक जो छोटा हाथी का बच्चा होता है उसको लोहे की संगलों से बांधा जाता है और उसके माइंडसेट में ये चीज हो जाती है कि मैं जितना मर्जी जोर लगा लूं मैं इस लोहे की संगल को तोड़ के नहीं जा सकता. और जब वह हाथी बड़ा हो जाता है तो उसको एक आम रस्सी से बांध दिया जाता है और उसके मन में ये चीज बैठ जाती है कि मेरे को अब कोई भी प्रयास करने की आवश्यकता नहीं है क्योंकि मैं इस रस्सी को किसी भी तरह से तोड़ नहीं सकता. तो आज आवश्यकता है, जरूरत है that we should do something at the grassroots level, at the family level. If the environment that we are going to provide to our children, the system that we have to respect women, we have to respect women. Just to sum up, चलता रहूंगा मंजिल की ओर, चलता रहूंगा मंजिल की ओर, चलने में माहिर बन जाऊंगा, या तो मंजिल मिल जाएगी या अच्छा मुसाफिर बन जाऊंगा. बहुत बहुत धन्यवाद.
Respected all dignitaries and मेरे साथ में जो दोनों बैठे हैं उनको भी और प्यारे बच्चों मेरे को फर्क नहीं पड़ता है क्योंकि मेरे लिए बच्चे भी बच्चे ही हैं. आज बड़ा अच्छा लगा था कि शुरू से हिंदी में बोल रहे थे, बहुत टाइम बाद मिल रहा है कि हिंदी में बात कर ले थोड़ी सी. ह्यूमन राइट्स, all human rights are the human rights. मिथ। मैं 2-3 दिन पहले मेरे दिमाग में ये था कि नहीं, ह्यूमन राइट्स, वीमेंस की ह्यूमन राइट्स से जो राइट्स हैं, मगर आज 2 दिन पहले मैं कुछ सर्च कर रही थी, 2 चीज़ें बताऊंगी आपको, मुझे बड़ा लगा कि ये तो मिथ है। मिथ क्यों है? क्योंकि एक ब्लैक बोर्ड करके एक यूट्यूब पे का वो आता है जिसमें लिखा पारो, यू नो अबाउट द व्हाट हु इज पारो, जिसको सेल आउट किया जाता है। तो एक मुस्लिम लेडी, एक गांव है इंडिया के अंदर, साउथ के अंदर, जिसमें एक मुस्लिम लड़की जो 15 इयर्स ओल्ड और जिसकी शादी उसके फादर ने उसे 30 इयर्स बड़े आदमी से कर दी, जो एक ब्लाइंड था और एक पैर लंगड़ा था, इसका मतलब, उससे उसकी शादी की। अब आप सोचिए कि जो 15 साल, किस लिए? सिर्फ 15,000 रुपीज के लिए, 15,000 के लिए। और वो जो गांव है उसमें मोस्टली इसी तरह की लड़कियां हैं जो बहुत छोटे उम्र की है और पैसों से उनको खरीद लिया जाता है। और फिर उनको इतना दुख उस लेडी को मिला है कि वो इतना रो रही थी उसके अंदर कि मुझे कुछ भी नहीं मिला जिंदगी में। तो आप क्या सोच सकते हो कि क्या प्रैक्टिकली ये सही है? ये एक मिथ है। दूसरी चीज है कि हमने जब देखा कि रेप हो रहे हैं, 4 मंथ्स के बच्चों के भी रेप हो रहे हैं, तो क्या रेप का आप ये मानते हो कि सॉल्यूशन ये है कि उसको कंपनसेशन दे दिया जाए? क्या करते हैं सरकार या कोर्ट, क्या कर रही है? कंपनसेशन दे रही। पर आप ये नहीं किसी ने देखा कि ये जो दर्द उसके दिल में उसकी फैमिली को लगा है वो हमेशा के लिए है। वो कैसे अपनी जिंदगी जीती होगी, ये सोचने की बात है। तो हमारे ह्यूमन राइट्स कहाँ चले गए? ऐसा नहीं है कि हमारे यहाँ पे, हमारी संस्कृति में, हमारे धर्म में, हमारे रिलीजन में अर्धनारीश्वर का रूप है। और अर्धनारीश्वर का रूप का मतलब क्या है? इक्वलिटी। दोनों बराबर हैं, चाहे वो मैन हो और चाहे वो वीमेन हो, दोनों बराबर हैं। तो उस चीज को हम भूल चुके हैं। हमें कभी भी इस ह्यूमन राइट्स की जरूरत नहीं थी एज ए विमेन, क्योंकि हमारा कॉन्स्टिट्यूशन, मैंने कंपैरेटिव कॉन्स्टिट्यूशन पढ़ाया है, तो हमारा जो कॉन्स्टिट्यूशन है वर्ल्ड का वन ऑफ द बेस्ट कॉन्स्टिट्यूशन है, जिसमें महिलाओं को सारे राइट्स मिले हुए हैं। ओनली द आर्टिकल 15 में स्पेसिफिक लॉ बनाने की बात कही गई है। वैसे आप देखा जाए तो हमारे पास सारे के सारे राइट्स वही हैं जो हमारे यहाँ पे मेन को मिले हैं। और जैसे इसने कहा कि एस हटा दो, तो मैं कहूंगी कि तो शिव के नाम से ई की मात्रा हटा दो तो वो शव हो जाएगा। और यदि इसका मतलब ये है कि जो एग्जिस्टेंस मेन की है वो विदाउट विमेन नहीं हो सकती है। तो हम ये कहेंगे कि जो भी है, आज इतनी सारी गर्ल्स, एजुकेशन, देखिए सबसे ज्यादा जरूरी क्या है हमारे लिए? एजुकेशन। यदि हमारे पास एजुकेशन होगी तो हम सब कुछ कर सकते हैं। और दूसरा है कि जब तक हम माइंडसेट चेंज नहीं करेंगे सोसाइटी का, तब तक कुछ भी नहीं बदल सकता है, चाहे हम कितनी ही ह्यूमन राइट्स की बात कर लें। ह्यूमन राइट्स का जो ये सबसे बड़ा उठा है, ये वेस्टर्न कंट्रीज से लिया है, हमारे लिए जरूरत नहीं थी। क्योंकि हमारे यहाँ पर, अब ये ठीक है कि कई जगह पे ऐसा होता है कि लड़कियों को मानते नहीं है, मार देते हैं, पैदा होते ही मार देते हैं। मगर हमारे लिए, मैं जिस स्टेट से आती हूँ वो गुजरात है, और कभी भी मेरा ब्रॉटअप ऐसा नहीं हुआ कि मैं लड़की हूँ। मेरा ब्रॉटअप ऐसे हुआ कि मैं लड़कों से भी बढ़कर हूँ। कभी मेरे पेरेंट्स ने, मेरी फैमिली ने, शास्त्री साहब खुद जानते हैं कि मेरी फैमिली ने ईच एंड एवरी टाइम मुझे सपोर्ट किया है। एक वाकया सुनाऊंगी कि जब मैं 10th में पढ़ती थी तो प्रेसिडेंट थी, स्ट्राइक हुआ, बॉयज की स्कूल का स्ट्राइक हुआ, मैंने भी उनके सपोर्ट में स्ट्राइक किया। उस समय मेरे ननियाल में थी, मेरे नाना डॉक्टर थे। मेरी प्रिंसिपल ने फोन किया मेरे नाना को कि डॉक्टर साहब देखो मधु बाहर बैठी हुई है और बच्चों को स्कूल नहीं आने दे रही है। मेरे नाना ने क्या पूछा? पढ़ने में कैसी है? बोले बहुत अच्छी है। फोन रख दिया। उन्होंने सबके सामने ये कहा कि देखो इसके नाना कैसे हैं, मैं शिकायत कर रही हूँ और ये पूछ रहे हैं कि पढ़ने में कैसी है। बोले मुझे मेरे नाना ने कुछ भी नहीं बोला। तो एक ये सबसे बड़ी चीज है कि आपकी फैमिली मेंबर आपको कैसे सपोर्ट करते। आफ्टर मैरिज शास्त्री जी का शुक्रिया है कि उन्होंने मुझे हमेशा सपोर्ट किया। नहीं, इट्स राइट, ये सब जानते हैं कि उन्होंने मुझे हमेशा सपोर्ट किया। और हम जब भी आगे बढ़ सकते हैं जबकि एक दूसरे के साथ चलेंगे। मैं आपको एक 4 लाइन सुनाऊंगी, इसके बाद में खत्म करूंगी। जस्ट अ मिनट। नारी नारी तू प्रयास कर, चल निकल प्रशस्त पथ पर, इस धरती का अभिमान है तू, हृदय भी दे दुआ जिसे देख, उस माँ की श्रवण कुमार है तू। तो सिर्फ थैंक यू वेरी मच।
We would like to thank all the panelists for their valuable guidance. The next plenary session will commence at 2:45 p.m. I would request our volunteers to kindly escort all the esteemed guests for lunch in Annapurna Bhavan.